Some of you all might remember this case. It's been a minute though. So if you don't worry. You don't have to go find it. We'll watch it again. Because I forgot. But we had a pretty good debate over whether this was just messy or an actual mental disorder. I looked it up in the DSM 5, which is like the Bible of mental health psychiatry. And hoarding disorder is classified under obsessive compulsive disorders, and it's the persistent difficulty of discarding with or parting with possessions regardless of their actual value. And it actually causes the person distress to get rid of the item. And it results in an accumulation of possessions to the point where if there's actual like paths and uncluttered areas in the living area, it's because of third party interventions. That's when it gets to that point, that's when it's considered hoarding. Just having a closet or one room stuffed full of things is not hoarding. Hoarding has to actually take over your entire life. And before it can be considered hoarding, many other things have to be ruled out, such as brain injury or several other physical medical conditions. And then psychological medical conditions have to be ruled out, such as schizophrenia or major depressive disorder. And once all of that's done, then it's actually considered hoarding. So you can't really just look at a situation and consider it hoarding. An actual psychiatrist has to do it. So anyways, this case came in front of Judge Simpson. There were quite a few fines assessed by the city because the homeowner failed to clean up the property. The city came in, cleaned it up, charged a whole bunch of money. But the thing is that the homeowner is not the person living at the property. You see, in Michigan, there is this thing called a land contract where basically it's like a rent to own thing. We had Big Tiff on before and she explained it in detail. Way too much for me, but basically they're renting to own it. They don't officially own the property until they pay it off. So there's an owner, and then there's the people who are living there who are kind of like the owners, but they don't officially own it yet, even though they're in the process of buying it. So in many other states, they would be the owners, but in this land contract, they're not, and they could lose it at any time. So when the assessments are being handed down by the township, they're being handed down to the actual owner, which is not the people living there who's causing the damage. It's a fun little shit show. So I've been keeping up on this case, and I have a little spy who's driving by the house taking pictures for me. So I will let you know what's going on because OMG, you are not going to believe what happened. But you got to watch the old one first to remember what happened before to see how it led up to where we are now.
All right, where are we on this case?
I don't think that we are any further than we were 2 weeks ago. There was a court hearing day before yesterday in 14A1. A new order for the zoning violations was issued along with, I believe, an order that allows the township to add more taxes to my escrow account, which I'm going to end up paying. This guy just is not going to clean this up, and he has not responded to any previous court orders. So I'm asking for the forfeiture.
Mr. or Mrs. Cox, any response?
Yes, Your Honor. I'm sorry that he feels that way. That's not my take on what happened when we were in court. 2 days ago, we were granted 2 weeks to have it cleared up. I discussed with the prosecutor and Mr. Toth. We had a private meeting. He had some paperwork, the prosecutor did, written up that we agreed to, my wife and I both, and we signed it, and we went into before the judge just to get that into the record. And it was us admitting that we were in violation and accepting that. There were fines that were assessed, and those fines are to be removed in the event that after this 2 week period we are in accordance with the ordinance. So I am cleaning it up. I had explained to the judge that we had a large
Let
yard
me
sale.
stop
and it
you. I
went
have a
actually really
copy.
well. So
Well, maybe.
I intend to do that again, and the property will be cleaned up.
Okay. I have a copy. I don't have a signed copy of the order. I'm presuming this is the order that by Judge Freshour that everybody's talking about. But there's another hearing June 6th at 11 a.m. is my
Correct.
understanding,
Yes, sir.
to determine whether or not there is actual compliance.
That's
Correct.
correct.
Mr. Carroll, you understand that, sir?
I do understand that, but I also understand there's been at least one previous order that's almost verbatim of this one. It hasn't happened. And I also understand this order, and after talking with Mr. Toth and the prosecutors, they intend on June 7th, if the property is not cleaned up, to go in there and clean it up and charge my tax escrow account another $12,000. And I'm powerless.
Well, I don't know what they intend upon doing, but you're asking me to do something that there's another court, my colleague, Judge Freshour, is overseeing it, and we'll hear a case on June 6th.
Your Honor, this is Mrs. Cox. Could I speak a moment?
Well, go ahead.
Thank you. The financially, as Mr. Carroll will say, we are completely even and up to date on everything for this property. We set for that last clean, which was much more invasive, taking 3 times and a semi being moved. I am paying monthly payments for that, my husband and I. I am on this as well this time, which makes a very big difference to my husband as well. So this will be cleaned up one way or the other. We also have a person going to be coming out and giving us an estimate to help my husband with the siding piece.
Folks, listen, everybody can tell me everything that they want. I can tell you right now, I'm not going to do anything until the review happens. That is on June 6th. Because there's an order basically indicating that certain costs need to be paid, the property needs to be cleaned up and brought in compliance. If it's brought into compliance, I think this action falls away. That's not going to be reviewed as to whether or not it's in compliance under Judge Freshour's orders until the June 6th. So, I don't know that the township's going to go in there on the 7th. I don't know anything about that. It doesn't say that in the order. I'm just saying there's not going to be a review until June 6th by the 14A3 District Court by Judge Freshour. So I'm going to give you my next available date after the 6th, which is going to be the 16th of June. So I'm adjourning this out to June 16th.
Thank you, Your Honor.
2023 at 9 a.m. and we'll have to see what happens on the 6th. That's the best I can do, folks.
Thank you, Your Honor.
Thank you.
Here, Your Honor.
Plaintiff is here. Patrick Cox, Laura Cox, they're not here. Would you like to take a default, sir?
Your Honor, to be fair to the court, there's a related case. I put in a request for a vacating of the trial date because the related case in 14A4, she gave him another 2 weeks to get that property cleaned up.
Okay.
Just because of the court's order last time, otherwise I would take the default.
So Judge Freshour gave until the 30th?
Gave until the 27th.
Okay, then let me
And the
put this to the 30th.
And the township.
I'll adjourn this out June 30th, 2023 at 9 a.m.
Thank you, sir.
All right, thank you. All right, this is a termination case. And where
Yes,
are
sir.
we on this?
Your Honor, I implore the court's wisdom of Solomon on this one. It's a really tough case. I will tell you up front that Laura has paid all of the payments. There is not a financial deficit except for the assessment for cleanup that the township put on it last year, but I had made arrangements with Laura to make those in equal monthly installments, and she is making those. However, since the last time the township went out to that property and cleaned it up and assessed my taxes, they put it on my tax bill, and I had to pay $15,000. And my escrow has increased my mortgage payment by $2,500 for the past assessment that the township put on as taxes, which was allowable by the court order. And they're anticipating that it's a tax, what's going to happen again. And I'm just losing my shirt right now on this. We went to court again on Tuesday, and another order was issued by 14A4 allowing the township to go back in and clean the property up because they gave them, and that was filed in February, and it's still not cleaned up. And she finally just said, township, go clean it up and assess the taxes. Unfortunately, the order that the township has proposed to that judge would allow them once again to put that assessment on my taxes, which means I'm going to end up paying it, not the Coxes. So I'm imploring your words of wisdom. I can't get them to clean it up. The township can't get them to clean it up. The court can't get them to clean it up.
Mr. Cox, what do you want to say?
Yeah, this is Patrick Cox. What Larry's saying is largely true, but the reality is that we don't ever get it cleaned all the way up. So I think that I just want to say that, and meaning that it's not something that I'm just ignoring. It's something that I have struggled to get done within the time that was allotted, and I believed I had enough time, and I was just wrong. So the property is in much better shape than it was. I mean, to some people, they may say that it's not, but it's just not. It's just not seeing the property the way that I see it because I walk it, and so the majority of what was nearer the street remains. And so I think that it just kind of casts an ugly look over the rest of the place. But having said that,
so
the
how long
truth
did
is
Judge
that
Freshour, how long did Judge Freshour give till the township's going to come in and clean it up?
She did not
essentially
give us-
immediately, but the township, I'm sorry, Larry, I didn't mean to cut you off, but just that I don't think she put an actual time on it, Your Honor. I think she just said they have the authority to do that. And I did ask in court with the prosecutor how long that might be before they came, because I'm fully committed to them not
And
coming.
what did they tell you?
He said it'd probably be about 2 weeks because his the guy from the township is on vacation, so he won't even be back, and then attempt to schedule it for
Your
I
Honor,
don't know the exact amount of time, but he thought it'd be 2 weeks.
Your Honor.
Yes, sir.
I did speak with Mr. Toth, who's the zoning administrator for York Township, and he did tell me that he has a July 10th date tentatively scheduled. Again, I have a motion before the court. I don't even know if I have standing, but I have a motion that I submitted before the court asking the court to prohibit the township from assessing my taxes and find a way to collect from the Coxes. I don't know if that will be successful. I don't know if I have standing, but if this is allowed to continue, I will lose that house.
All right, but That motion is not before me, is it?
No, it's before Judge Anna
Fresh hour.
Fresh hour, because she's the
Yes.
one that made the ruling, and she's the one that's going to approve the
Right. So
language.
when is that motion set?
It's not said. I haven't heard anything from her. Again, I don't even know if I have standing.
Okay, I don't. Got it. Okay. So here's
And
what
Your Honor-
here's what I'm gonna do. You realize you've got 10 days to do that, but the thing that I'm also gonna do in this case is I'm going to allow the plaintiff to amend the complaint to request damages. It's another thing in terms of getting paid. So what you'll have to do, sir, is you'll have to pay the difference in the filing fee for the damages
Okay,
portion of it, okay? And then I'm going to adjourn this out to the 14th. If it's not cleaned up and the township has done it, if you have a township bill, then I'm going to allow those as damages against the Cox in this matter.
Okay. I'm not sure I entirely understand it, but
Okay,
but
so
I
here's the
agree with
bottom
it.
line to it. You guys are supposed to clean that property up. The property has to be cleaned up. The township, Judge Freshour has ordered that the township do it if you guys don't do it.
Correct.
And plaintiff in this case is saying, well, if the township comes in and does it, then I owe the money and you guys are supposed to pay it back when you're the ones that are supposed to be keeping it clean. So what I'm
Right.
saying is if you guys don't get the property cleaned up, I'm going to give a judgment, a monetary judgment, not only for the property, but a monetary judgment to the plaintiff for whatever the costs are in cleaning it up.
I understand. All right. That's more than fair.
would
Okay.
this court entertain a motion prohibiting the township from assessing my taxes?
That is not my case. You'll have to bring that before Judge Freshour.
I appreciate it, Your Honor.
All righty. July 14th, 9 a.m.
Good morning, Your Honor. Dan Troika appearing on behalf of the plaintiff. Lawrence Carroll.
Yes. Yes, good morning, Mr. Drake. That was, that helped a great deal. My blood pressure came down quite a bit. All right.
So, Your Honor, I understand you're very familiar with this case. I'll try to bring it, and I would say you probably know more than I do, but I would like to bring to Your Honor's attention what I understand has happened since the last hearing a couple of weeks ago. I will also know for the record, Mr. Carroll is present. If the court has any questions, also Township Council is present, as well as the Township Building Official. As I think the court knows, my client filed a forfeiture action, and the forfeiture notice of forfeiture and the forfeiture complaint are alleging that there are non-compliance issues with Township Code, mainly the International Property Maintenance Code. And I think Your Honor was informed 2 weeks ago, Judge Freshour in Chelsea issued an order permitting the township to go in and clean up the yard, which apparently has a lot of masonry contracting debris. And the order also permits the township to replace the siding on a side of the house that was removed by the buyer over a year ago, or about a year ago, and is also a code issue. So I just found out yesterday from speaking with Township Council that the township did in fact go and clean up the yard, but they have not addressed the siding. And frankly, that's a very, very difficult issue for the township to do. I also learned yesterday that on top of the $14,000 assessment we got last year when this happened, we're going to get a new $13,000 assessment based on what just happened, and the siding issue had not been resolved. So, Your Honor, in some respects, this is similar to what the hearing you just had, in that what was presented to Your Honor is, hey, there's a condition on the property that has to be solved. We have a different judge saying, here's how you do it, township, you can go in and take care of it. And the township did do that, except that the township has not replaced the siding. So the Judge Freshour's order and the property violations are still in effect as we speak today as to the siding at a minimum. And I will add, by the way, I'm assuming the other outside issues were addressed by the township. Mr. Toth may contradict me on that, but that's my assumption. Your Honor, after going through this with my client at some length, I was told and would like to confirm that Your Honor has suggested you would be open to us filing an amended pleading. And what I would like to do, if the court would permit it, is to amend our complaint to keep the property violation issue because there's still a siding issue, and also because this is recurring. We think it's going to just pop right up again in the next week, 2 or month, as it has over the last 4 years, and also to demand that we be paid the assessments, which are now like $27,000. This is a huge problem for Mr. Caro. He is between a rock and a hard place. He, without relief from this court, he's going to keep getting whipsawed with the township actions against Mr. Cox in perpetuity. And just Mr. Cox seems incapable of maintaining that property to code. And I think Your Honor may be aware from pictures, it's not a close case. We don't get it, but all indications are he's just unwilling or incapable of satisfying the township. And the township, I think, has given him, all the leeway they can. So what I'm seeing in the future for Mr. Caro without relief in this court is pretty bleak. It's going to be just one township action over another. And every year, 13, 14, 15 grand assessed, which means he's going to lose that property because he can't continue as a seller under a land contract with his own mortgage and have to deal with that kind of expense. So I don't think there's any dispute that the land contract buyers are on the hook for the township expenses, which are again now around 27 grand. What we want to do then is make that claim, which I acknowledge is not before the court at the moment, but the land contract forfeiture rule clearly empowers the court to allow amended pleadings. I think that's probably the only way to force the issue. And if there's any hope that this land contract can be successfully, played out, it's got to start with some consequences for the Coxes for just being unwilling to satisfy the township. So Your Honor, again, I think you probably know more about the case than I do. I've done my best to come up to speed and come up with a solution. But that is my proposal, that the court, acknowledge that we have leave to file an amended complaint that would allow the Coxes to respond and their rights will be protected. But we can then go forward and join the issues that really are affecting Mr. Caro, that being the continued property violation, at a minimum, the siding, and these assessments, which are now, in the stratosphere as far as land contracts go. And while, Your Honor, I know it's over 25, this is not a money judgment issue. This is a redemption issue if the court were to give us that judgment once we had a hearing.
Anybody else want to address the court on this? All right.
Yes, John, I'm sorry.
Go ahead.
This is Patrick Cox, Your Honor. We were assessed fines for the first cleanup that took place. And when we found out about being assessed that amount, it had been worked into our summer taxes. And I don't know how or why that happened. Maybe that's just how it happens, but that was something that that we just found out that that's how it was being taken care of. And we spoke with Mr. Caro, and he wanted to work with us yet to see if there was a way to keep things going. So some numbers that he put together that we trust in, we have no issues with what the numbers are, based on what it would cost him over the long term. We pay a second payment to him every month on every 2 weeks to buy down what that cost is that was associated with the first cleanup, and that was all at his request. And so we've satisfied that, and we've made every payment. I did have this issue again, and it came up, and they came out and they did clean the property. And I wasn't aware of what that assessment charge was until just now when he said that it was $13,000. And I don't know if that,
Sir,
Yes, sir.
Mr. Cox, let me just stop you for a moment.
Sure.
Let me just say this. When I was doing the Saline docket, I've had this before me before. So this property is not this, none of this is really a surprise for me. I think two things are happening here which are causing a problem. Mr. Troika, I think, is correct that some of the issues that are being dealt with by my colleague, Judge Freshour, can be dealt with in this case. When Mr. Carroll came before me last time we were here, his fundamental issue was really getting this assessment again and trying to think of a way in which that assessment wouldn't be as against him because he doesn't think he should pay it because he's not really causing this problem. Whether I agree with that or not and how that would happen, that mechanism, it doesn't really matter. But what is really complicating this, in my opinion, is trying to have two judges resolve the same issue effectively in two different forums in two different forums. So in that regard, here's what I'm going to actually order. And this judge will cooperate to the extent I can. I think one of us, either Judge Freshour or myself, will need to handle both of these cases. Plain and simple. That way, we don't have a problem with what needs to be enforced or anything along those lines. I would allow the plaintiff to amend their complaint to bring all of those issues in, bring that other case, I guess, here. Because I'm not going to bind Judge Freshour to try to take one of my cases. I certainly would be willing to take the case. So I need somebody to raise that. Certainly I could call Judge Freshour and find out, but I need somebody to raise that to Judge Freshour. We would then touch base and the case would just come over to me. That seems like, from my standpoint, the better way to handle this whole thing. You may not like the rulings you get that come out of it, but at least it's all in one spot and you can look at one judge and say they did it wrong. All right. Anybody have any objection to that process?
And Your Honor, I'll state I do not. Township Council is present. I mean, they're actually the party before Judge Freshour. Larry Carroll is not a party in that proceeding. I don't mean to put him on the spot, but if I guess I'd like to know if Township Council is okay with that, because
Mr. Lillick never wants to see me. That's okay. No.
Your Honor, Victor Lillick, as you know, I represent York Township. Yeah, you know, frankly, the case before Freshour, Your Honor, it's done at this time, except the requirement that Mr. Cox put the siding back up on the property. That's not an enforcement issue that the township's not going to take care of that. The township will go onto the property and clean up the property when it has to, okay, and only when it has to. And in this particular case, it's become necessary. So we've done that again. So that particular violation, at least for the moment, is resolved. However, we don't have any expectation that that's going to continue to be resolved. We fully expect that Mr. Cox, as long as he's living there, will probably begin accumulating materials again in violation of the township ordinance and frankly the court's order at this point. So, I mean, I don't have an objection to one judge handling this case. I would just indicate to the court that from the township's perspective at this point, we're pretty much done until we have to go back in and enforce the order again.
So, and Your Honor, if I may.
Right, but and that I think is where the problem can come in terms of enforcing the order and coming back again. And that's what I'm trying to prevent, because you'll be headed back into one court. Then next thing you know, this is Mr. Carroll's coming into here to do this. It just doesn't seem to me to make any sense to do it that way. So.
Fair enough, Your Honor.
And you guys are, you know, the last 3 times you guys have been here anyway, so I have
True.
2 here. So, all right. So
Your Honor,
why don't I do this? Go ahead. What were we gonna say?
I was just gonna say, as far as the, administratively, how this works, I mean, do you contact Judge Freshour or?
I will let Judge Freshour know, but it would be best if the township let Judge Freshour know, or something, the parties here let Judge Freshour know, and then we'll touch base.
All right.
I'll try to do.
I'll reach out to her administrator, Your Honor.
All right, so I'm going to adjourn this to August 18th is my next.
Yes.
August 18th, 2023 at 9 a.m. And that way it'll allow you to get what documents you need here. I'm sure the 2 courts, once they're contacted, we can then get the file over here if necessary, and start moving this along in a more streamlined fashion.
Yes,
Okay.
and Your Honor, I'm sorry, if I might, Your Honor, there is actually a hearing that's scheduled before Judge Freshour on the 30th of August, okay? Now, if Mr. Carroll, okay, filed a motion in that case. He's not a party to the case, and so I'm not certain.
Yeah, I know.
Okay, all right, so
Yeah.
in any event, that's scheduled for the.
Yeah,
30th. I just wanted to
Mr.
put it there.
Carroll, I think, had indicated he had filed the motion, was looking for me to rule. I couldn't rule on it. And I knew he was I knew he was filing a motion. I didn't know when it was scheduled, but so that's set for the 30th.
Yes, Your Honor.
And that's set before Judge Freshour.
Yes, it is.
And so if everything were to come over to me, then Judge Freshour wins, because then she doesn't have that hearing. I don't think she's going to have an objection.
And Your Honor, we can address that motion on the 18th. I mean, not hear it, but we may need to withdraw, refile it. That was prepared by my client in pro per. I don't actually know what it says, but we will have an opportunity to meet with Your Honor before we have to deal with that motion. And it's possible we'll, in the meantime, have worked things out with the township.
All right, very good. Then what I'll do, I think everybody has their marching orders then, and I'll see you guys on the 18th.
And Your
9
Honor,
a.m.
we will, in the meantime, file an amended complaint.
Yes, sir.
So
Okay,
that's the 18th at what time, Your Honor?
that'll be set at 9 o'clock. You may 9 o'clock block.
Thank you, Judge.
Thank
Thank
Your Honor.
you.
Thank you.
Folks. Lawrence Carroll versus Patrick Cox.
Good morning, Your Honor. Dan Troik appearing on behalf of the plaintiff, Lawrence Carroll.
Plaintiff Lawrence Carroll here.
Patrick Cox, I'm here.
All right.
Laura Cox is
I
here.
have had, so that the parties are aware, I have had the 4, looks like, cases, municipal civil infractions, I believe they are, that Judge Freshour had assigned to me. So I now have all of those cases because I didn't have enough to do. So I have all of those cases. So where are we now on this, folks?
Your Honor, a few things have happened since our last meeting with you about 3 weeks ago. As Your Honor just noted, we did consolidate the cases. You might recall Mr. Carroll was getting whipsawed between the enforcement proceeding and the forfeiture proceeding, so we've addressed that issue. We also filed an amended complaint, and in this case, we're seeking that the Coxes actually pay the assessments that the township has made to clean up, and that's about $24,000. And Your Honor, we filed a motion for entry forfeiture judgment, which is, we don't have a hearing date yet, but that is our effort to finally get relief here. I think the court is aware that for 4 years, we've had this problem with the Coxes simply incapable, apparently, of keeping their property up to maintenance standards. Because of that, the township has filed several enforcement proceedings. That's resulted in costs assessed back to Mr. Carroll. It is just basically a situation which we need some ultimate relief. So we have requested that in the hearing that will be before Your Honor when the court schedules it. So that what we're asking, and again, we'll argue this later, but we're just so the court understands, we're going to be asking for a redemption during which the Coxes can basically put up or shut up, because we just can't be in a situation where every 6 months we're getting sued again, and they're unwilling or unable to keep their property up to code. So we're hopeful that that will put the thing on a path toward either compliance by the Coxes or getting them out of the property. One or the other has to happen.
All right, Mr. Cox, anything you want to say?
Not specifically, sir, no.
All right. Well, I guess part of the issue, the property has been, I see Mr. Toth here, or Officer Toth. The property's been cleaned up at this point in time, correct?
Your Honor, if I might address that, Victor Lilick on
Okay.
behalf of York Township in those cases, Your Honor, the township cases. So it's reported as of yesterday that actually we did clean up the property, but actually it's reported as of yesterday, and we have some pictures that they are starting to accumulate junk on the property again already. We have judgment in the York Township cases. My intent at this time, Your Honor, would probably be to file a motion for an order to show cause and contempt for violation of those orders. And I guess if it's possible, we would try to have those on the same date that Mr. Troika wants to have his motion date, Your Honor.
Good. I think that might be, I need a second sheet. Space. Okay. Mr. Cox,
Yes, sir.
are more things appearing on the property? I mean,
Absolutely not. I did know that was going to be Mr. Toth's claim, because I saw him yesterday scurrying about. But it is, they did come and they did the clean. But I have, and I'm not done yet. I've gone through the property collecting what was left, and it's substantial. I was just trying to mow, and there's stuff that I'm not complaining about it, but there's just stuff that was all over the yard, and there's a lot of things that they did not take. So that's just me cleaning up my yard, and there is nothing new that's been brought to the property. That's just not true. So I'm remaining in compliance as far as that goes, and I continue to, my attempts are still to clean the property thoroughly.
all right. Mr. Lilick, how long will it take you to file your motion?
Well, Your Honor, I can put that together today, probably.
Okay.
And get,
All right.
I mean, I think I could probably file that via email, correct? Is that acceptable to the court now? Or?
That with the court, if you send it to Ms. Weidling and then send it also to the clerk's office, that will be the actual filing of that.
All right.
14A office. And then Mr. Cox, have you received a copy of the motion for entry of forfeiture judgment?
Yes.
Yes.
This is Laura Cox.
Okay, how are you going to answer that motion?
I guess I'm not sure how we do that, Judge Sinsman.
Okay, you would have to file a written answer stating, in essence, answering the allegations put forth by the plaintiff and basically stating to the court what your position is on the forfeiture.
Yes, then we will answer that motion.
Okay, how long will it take you to file the answer to that?
7 days.
Okay,
I just want to seek counsel for that.
got it. I'm going to suggest to you, if you're going to seek counsel for that, that you also seek counsel regarding the show cause motions that are coming forth. Okay,
Okay, thank you, sir.
all right. So I'm going to indicate that your answer to the forfeiture motion is going to be due. If you're going to get an attorney, I'm going to make that due by the 29th, by August 29th.
Thank you,
Okay,
Your Honor.
and then I'm also going to indicate that that's also to the forfeiture motion as well as to any show cause motion. So I'm building some time in there so that you can get those when Mr. Lilick files them, and all of those answers can be filed by that date.
Thank you,
You
Your
understand
Honor.
that?
Yes.
All right. Then what I'll do is I'll set a hearing. Let's give them Tuesday.
Oh, Tuesday?
Okay, hang on.
Tuesday, September 5th, or I can kick it out further.
They get everything into me on the 29th, but I got a holiday coming in there. What's our next date after that?
So after that, it would be Tuesday, the 12th
The 12th.
or the 19th.
All right. I can set a hearing on all the motions and the request for show cause, or the show cause and request for an entry of a other relief. I can set that for September 12th, if that work with the parties.
Your Honor,
That's fine.
What time, Your Honor? Because I do have a docket at 11 o'clock in front of Judge Freshour, I think.
Is that, are you doing that docket in person or?
No, that should be Zoom, Your Honor.
All right, so what I will do is I'll set this hearing on the motion for September 12th, 2023, 9 a.m. That will be in person here at 14A1. There are rooms out here where you could Zoom into Judge Freshour, and I'll accommodate that certainly for you.
Thank you,
Your
sir.
Honor, is there ability for us to attend Zoom? Because I will be in Illinois.
Somebody's gonna have to be here. Is Mr. Cox gonna be here?
I will be here and available.
All right, so you need to be here. I don't like to do that, Mrs. Cox, but I will allow you to appear via Zoom
Thank
as
you,
long
Your
as
Honor.
Mr. Cox is here.
I will be, and thank you for allowing her that.
Your Honor, did you say September 12th at 9 a.m.?
Yes, sir.
Your Honor, one other housekeeping thing. My client, when he was without counsel, filed a motion against the township in the enforcement proceeding, which was scheduled for August 30th. We're going to withdraw that without prejudice at the moment, and I'm not even sure if that date carried over onto your calendar, but I wanted Mr. Lilick to know that he doesn't need to file a response and that we're not expecting a hearing on August 30th.
Right. Thank you for that, Mr. Troika. The August 30th hearing, because the cases got transferred, that also got canceled. So
Okay.
we were going to reset it, but we won't reset it if you're withdrawing the motion.
Thank you, Your Honor. One last thing, I just want to be clear for the court and the Coxes that there's an order for them to replace siding on the house that's separate and apart from the accumulation of clutter outside. We'll discuss that on September 12th, but Your Honor should be aware that that still hasn't been done, and that is part of what will be before the court.
And that
All right.
will be a part of the show cause order too, Your Honor.
Yes. Okay. All right. We'll try to deal with everything on that day. All right, folks.
Thank you. Your
Thank
Honor.
you. Mr. Cox, if you can come up, you can have a seat at that table. That's fine.
And the York Township case, Your Honor?
Yes, and also the York Township. Go ahead.
So good morning, Your Honor. Dan Troika, appearing on behalf of the plaintiff, Lawrence Carroll, in the civil forfeiture case.
All right.
And Victor Lilick on behalf of York Township and the York Township case, Your Honor.
Your name, sir?
Patrick Cox.
All right, and Laura Cox, if you could just state your name, please, for me.
Laura Cox.
All right, thank you. All right, Mr. Troika.
And, Your Honor, I also note that Larry Caro is appearing by Zoom. So Your Honor is very familiar with this case in one form or another. It's been before this court or Judge Freshour over the last 4 years. Basic issue that keeps happening is that Mr. Cox, who resides at the premises, keeps accumulating materials outside the house. We don't know why he does it, but it has been a concern to the township. Township has repeatedly gotten orders, both from Your Honor and from Judge Freshour, to clean up. Mr. Cox has repeatedly not cleaned up. As a result, the township goes in, they clean it up, and then they charge it back to the property. Mr. Caro has been stuck with about $12,000 in already assessed taxes against the property based on the cleanup. And there's another $13,850 that Judge Freshour authorized this summer, which will be presumably added to the tax rolls in December. We might object to that, but that's just where we are at the moment. We have not had any control over what's happened in the property code enforcement cases. So Mr. Caro, acting in pro per, filed a land contract forfeiture case back, I think, in January. The situation is unusual. The Coxes, in fact, do make their monthly payments. They made their September payment. So, we're not here telling the court that they're not making the regular installments under the land contract forfeiture. What we are here telling the court is that it's their obligation under the land contract to pay what we've been obligated to pay to the township, which is, that's in my motion, is $24,000 and change. That's a cost that is expressly on the Coxes and not on Mr. Caro. And we've asked the court to enter a forfeiture judgment that would require them to pay that amount in order to keep possession and an interest in the property. We have to have some solution here. This is a situation that's just going to keep going on forever as long as nothing happens. So our proposal is the only one we can think of that's consistent with the law and that will force a solution. They're either going to pay what they're supposed to pay and comply, which is part of what we put into our request, or they're not. And if they don't, then we'll be back in here seeking possession with a forfeited land contract. It's not our desire to kick them out. It's not our desire to claim any equity in the property, although to be frank, we haven't seen the interior. We doubt there is equity at this point, but we got to solve this problem. Mr. Caro can't be getting bills of $12,000, $13,000 every 6 months because Mr. Cox is incapable of keeping the property up to the standard of the code. I'm, all open to suggestions. I know Your Honor is a fair judge and also can be creative. I've done everything I can to think about this. I can't think of any other solution other than to get our forfeiture judgment, and either they put up or shut up. I mean, we are at a point where this has gone on for 4 years. We can't have it keep going. Now, I wanted to address a point. I know it came up before I was counsel of record in the matter, and I just heard it in the last matter. In a lot of these cases, there's a question about acceptance of payment after sending your notice. And in cases where it's a notice to quit for a 1 month, month-to-month tenancy, if you accept rent for a period after the termination date in your notice, then you have essentially voided the notice under the Park Forest case. That comes up all the time. When I first got this case, the first thing I did was look for the law on land contract forfeiture, and there's only one case in the state of Michigan, and that case squarely says that when it is land contract forfeiture, not only are you permitted to accept payments after your notice of forfeiture, you are obligated to. You take them, you apply them to the balance, and we've done that. They're credited for what they've paid if they are able to do what they're supposed to do during the redemption period, then they'll get the benefit of their bargain. But the issue is we just can't keep having this problem come up. I'm not optimistic. We were in court not that long ago on August 18th. And while the township will speak to this, I've seen the photos. The junk is accumulating again. It's growing like a fungus. It just happens. I don't see this ever stopping. So we're asking the court to grant our motion. I wanted to add a couple of technical things. We didn't get a response to our motion. We did send in a request for default last week. We didn't actually ask it to be entered. We asked it to go to Your Honor, so you would know that we properly made a request for default since they did not get counsel. They did not file a response. They didn't do what you told them to do by last week, I think it was, or no, I think it was August 28th. They were supposed to do that. Two other things, which I'll tell you, as an officer of the court, I want to be straight on everything. In my motion, I requested a 30-day redemption. The rationale is that we're suffering damage on essentially a daily basis, but I will acknowledge that the statute says it's going to be 90 or 180. And if it would definitely be 90 if your court follows the statute, because they've only paid about 245 out of the 280 balance. If the court would consider a shorter redemption based on these circumstances, by analogy, that does happen in mortgage foreclosures and the termination of tenancies. But for land contract forfeiture, the statute says 90 or 180. If the court does not believe there's an equitable basis for deviating from that, then it would be 90 days. And one last point, in the order I proposed yesterday, I included the provision that we would have a right to inspect in 48 hours notice. I don't know if that's objectionable to the Coxes. The reason I did that is because we received an inquiry from somebody who said they might want to buy out the property, and they said maybe they can solve this issue. Again, I'm not optimistic, but there's no real way we can do that without actually having the ability to see the interior of the building. If the court thinks that's unfair, I understand it, but I do believe we have a right to inspection under the land contract, and I don't know that the Coxes would disagree. I mean, we are looking for a solution, but whatever the solution is, our preference is to get bought out. But if that doesn't happen, we want them out of the property, and if that doesn't happen, it should be because they're abiding by their obligations under the property maintenance code and satisfying the township. We obviously don't control the township. We are essentially asking the court to make them pay us what we've been obligated to pay the township, and to make the township happy on the issue of compliance. I just think that's unassailable. I don't know what else we could ask for. And the alternative for Mr. Carroll is getting basically strung along for the indefinite future, to the point he's wiped out financially. It's not what he signed up for. And while, I'm not here to cast aspersions on Mr. Cox, I don't know what motivates him. He just doesn't have a right to do what he's doing and create these problems for us, either for the township or for Mr. Carroll. So we would ask the court enter our order with the caveat, as I've explained, about the redemption period and the inspection right. And of course, Your Honor gets to make the decision, and we abide by whatever Your Honor would rule. Thank you.
Well, let me just ask real quick. The land contract requires that the Coxes pay the taxes on the premises.
It does that, but it also says they have to pay repair costs if they create a problem. So that is explicit in the land contract. I relied on two different provisions for the assessment that was already assessed last December. We relied on provision 2E, which says they have to pay all taxes and assessments. So I think that's ironclad. For the $13,850, which just happened, we relied on 2B, which says that they have to keep the property in good condition. It explicitly says they have to comply with any and all building use and other restrictions, and they can be liable for cost of repair if they don't. So I submit that's sufficient to support an order from the Coxes to pay the $13,850. In my proposed judgment, they would pay it directly to the township within the redemption period rather than us. We're not looking to make a profit here, but we don't want to be assessed again in December. And Your Honor should know that for Mr. Carroll, this was a big problem. Last year, when the township assessed his property, his mortgage company then took that to be the new tax, and they increased his escrow catastrophically. Although it turned out maybe they were right, if this is going to happen every year or even twice every year, but it created a big problem for him. So our request respectfully is that they be ordered to pay the township, and if they comply with the order, if you enter it, then we're not going to have the issue of an assessment come December. And we do reserve our rights on the issue of assessment, but we're not here to argue with the township, and we're doing our best to cooperate. Thank you, Your Honor.
Just one other question. Assessment of the $13,850, is it $13,850?
Yes.
Okay.
Yes, and that's coming from the township. Yes.
Right. That assessment won't happen until December of 2023.
The assessment on the tax rolls, as I understand it, will not happen until December. Mr. Carroll did file a motion with Judge Frushauer, which we withdrew without prejudice, challenging the ability of the township to assess the property as opposed to Mr. Cox personally. We're not obviously arguing that today. If the court did grant the relief we're requesting, then the Coxes would either be paying the township directly and avoiding the assessment, or they would be forfeiting the land contract.
All right. But there, as I see it, just so that unclear, maybe Mr. Lillick can answer this. It becomes an assessment at some point,
It does, correct.
but then there's another point, and it could be the same, but there's another point at which it hits the tax roll.
Yeah, what I would say is this, and Mr. Lillick knows more than I do about municipal law. I don't think it's currently an assessment. So Mr. Caro doesn't currently have an obligation out of pocket to pay the 13,850. What I would say is the Coxes currently have an obligation because the land contract places upon them directly the cost of repair. Now, if Mr. Caro had gone out there on his own and done the work, which I wish he could have done, but he didn't feel he could do so safely, then we would be able to come to your honor and say that cost should be paid by the Coxes to Mr. Caro. That's not what happened. The township did the work. We do think that it's ripe because assessment is not the only basis for our request. The additional basis is that they're on the hook.
I follow you. But
Yes.
what's clear in terms of the language of the land contract is that for it to be an obligation that the Coxes have to pay. You're right in terms of the repairs. Get that. But it seems to me almost a more straightforward approach, maybe, is to figure out when this is an assessment. Because at some point, I guess, once the court orders it, it is an assessment against the property.
In a meaningful sense, yes.
Well, I think that's when the assessment happens. What then the township does with that assessment then becomes another issue, because then the township's going to say, okay, this has been assessed against your property. Part of our remedy then is that it hits your tax rolls, because that's the way I see it. Mr. Lillick, can you?
So the way that the order is written, of course, is that the obligation is on township to provide an itemized statement to the defendants regarding the costs that were incurred by the township with cleanup. That was done. It was not paid. And when it's not paid under court order, then it becomes an assessment that is attached to the property. We have not attached it to the property at this point because we're cooperating with Mr. Troika and his client to try to avoid that consequence if we can.
But it would be
December 31st when it would become attached as an assessment, basically.
Well, hold on, because I don't want to get lost in these words, because I think there's a difference between the assessment, at least in this court's mind, is actually occurs when it's not paid.
Correct. I mean, essentially, Your Honor, yes.
Yeah, I mean, that's when the assessment really happens.
And
On the 31st, that's when it may attach to the property and become part of the taxes.
Right. The township has to make that decision and place it on the rolls at some time in October, I think.
Okay.
So.
See, that's what I'm getting at, because the way I read the land contract, assessment and the taxes are those are different things in the court's mind. So if, for example, you were in a circumstance where, let's say, somebody supplied snow removal, the snow removal, and by agreement, it maybe could go on tax rolls at some point when it's not paid. I assess it at some point and then take my further remedy to attach it to the property and it becomes part of the tax roll. So just so that we're all clear, I view those as very different things. I think that the assessment of the amount of the 13,850 has occurred unless somebody shows me something different. And I think it becomes part of that land contract at that point.
And Your Honor, that assessment has occurred and it has not been paid.
Correct. So I don't know that I need to get to the issue of whether or not it's attached to the properties and on the road. I don't know that I need to get there, because under the terms of the land contract, the Coxes would be required to pay that assessment. And so, bottom line on that, and I'll hear from Mr. and Mrs. Cox, but where the court is at this point, is that 13,850 has been assessed and is now part of that land contract. That's my current view of this. Mr. Cox, what do you want to say regarding?
I think
You can either speak from there, you're fine, or you can come up to the podium, whatever you're comfortable with.
I would like to just say that I'm some of these things I'm a little bit confused. But I generally have a grasp of it. And I don't mean this in a disparaging way towards Larry, Mr. Carroll, but there it seems like the tenor of all of this is that I'm failing in every way, and woe is Larry. And I don't mean that in a bad way, but this assessment that was made to clean up the property before, Larry approached my wife and I about a resolution. We did not go to him to look for one. And he offered how that might be done. And so we were to pay him an installment of that every month on the 15th. So mid-month, we were to pay him, and he seemed satisfied by that remedy. So we would pay our mortgage payment, which we have always done, and we would then pay this additional amount mid-month so that he could pay that to his mortgage company, and we would pay all the interest on, I'm sorry, yes.
So what was that amount?
$500 a month.
550.
What?
It's 550.
550.
Okay, so, and I'll let you finish,
Sure.
but I became a lawyer, so I didn't have to do math. But if I look at that 550 being paid, here's what I see in the problem in that. That assessment that's been done can't be paid, like it wouldn't be paid in a year with the additional 550. Let me just say
It
one
was
other.
24 months of payments.
Okay. All right. So that about gets you there. The problem with that, though, is there's this 12,000, which I can see then the 24 months of payments. I get that. But the problem that I see in it is that now I've got this 13,850 that if the 550 kept going, that won't get touched until 2 years down the road. And then it's going to be another 2 years plus before that's paid. And the way this is going, hold on just one quick second. The way this is going is that if this happens again, there's going to be another assessment, and it's just pushing this thing out so that this number becomes bigger.
No, it's not a
Each time.
sustainable thing. There's no question.
Right.
And I'm not suggesting Larry's under any obligation to offer us that same setup in what is this new assessment. But I was just giving the ground for what happened on that first go around. So the fact that Larry has kind of even said it to us that he's being he's losing all this money, and he's gonna fail, he's gonna bottom out. It is still ours at the end of the day, and based on his own design, this would be something that would not hurt him, and it would benefit us. We appreciated his offering it to us like that, because we recognize that he could have called it due. It wasn't his problem, and we've never suggested that it was. Now we have this new assessment, and that's something that can be dealt with in an entirely different way, and he could insist that be paid. in the event that weren't able to pay for it, were gone. I recognize that, but I just wanted to say that that first go around, and that first cleanup, we are taking care of that, and we are doing what it is that Larry has asked us to do, and so it only
Well,
makes sense.
let me ask you that. Let me ask you this.
Sure.
Have you made the five? I think your wife, Ms. Cox, I'm sorry, Ms. Cox said it was $550 a month. Is that correct, Ms. Cox?
Right.
Yes,
Okay. Have you made those payments?
Everyone.
I have never missed a payment. We have
Okay.
never missed a payment. I'm sorry.
Just trying to, you guys have been there. I'm kind of coming in.
Right.
And so how many of those 550 payments have you made?
I believe February was the first one. So we would have made 7 of them. We've paid 35. It's either 3,500 or 4,000 at this point.
Gotcha. And that's of the 12,000
Correct.
that we were looking at. Is that right?
Yes.
Correct.
On the first on the
That's
first.
right, that's right.
Right. Okay. All right. Council, do you agree with that? What?
Your Honor, I attached as Exhibit 4 to my motion, the actual agreement. And I think it's important that the court hear what it says. On January 18th of this year, Larry Carroll wrote to Laura Cox and said, "Hi, Laura, here's my proposal. This is contingent upon no further citations and certainly no further assessments against the property in 9384 North Platte. I understand Patrick believes the property is cleaned up and he will have the house wrapped by this weekend and the house fully cited by the end of March. If this is not followed, this agreement is null and void and the full taxes assessments will be immediately due." So Larry extended this payment plan on condition that this problem stop. It did not stop. Instead, there was a new accumulation of debris. There was a new assessment of 13,850 based on a new cleanup. The siding has still not been replaced. It was supposed to happen by March. And now, Your Honor, we're only here talking about the 2 existing assessments. We're now in the run-up to a third, because since the last cleanup in late July, I think July 28th, there's a new problem, which is why the township is here today with photographs and I think video to show that it has started all over again.
Hold on.
Well,
I'll give you an opportunity. Hold on.
But I will say clearly, Mr. Carroll's payment plan to the Coxes was conditioned on this problem stopping. If it had stopped, we wouldn't be here. Mr. Carroll was fine with that agreement. You know, he was going to get paid and he was going to be made whole on what the township had assessed his property, but it was conditioned on not having further problems. They failed that condition. We're here because they failed that condition. The township is here. They held them in contempt in front of Judge Fleischauer after this agreement, and they're here asking Your Honor for contempt again after this agreement, and the siding is still off. You can see in the photographs the township will show you today, they just didn't do what they needed to do. So yes, it was a good deal. It was mutually beneficial, but they didn't hold up their end of the bargain. And so we're at a point where we want to and believe we are entitled to force the issue. If the court's going to go with 90 days redemption, they're still going to have 3 months to make this work, and they'll have 3 months to get a buyer, which would allow Mr. Carroll to be made whole, and they could get whatever equity they think the property has. So they'll have time. But if Your Honor doesn't give us relief today, then this is just never going to stop. I mean, unfortunately, it's driven by Mr. Cox's behavior, and I don't mean that to be insulting, but it just is. And we're well past the point of believing any promise that it's going to stop. So that's our reasoning. Thank you.
So I'll let you go in just a minute. I just want to get my figures right. If the total amount of assessments and or taxes, I have 25,850.
Well, we did give credit for what they have paid. So in our proposed judgment,
Right.
it's 24,018 and then a $20 motion fee.
Okay, so I'm still lost on the numbers. I want to get this straight because I have assessments and the other thing of 25,850. That's the 12,000 plus the 13,850.
Correct, but they paid some on the 12,000 and we gave them credit.
Right, and that's what I'm getting at. Because if I hear Mrs. Cox correctly, they paid 7 months.
That's roughly correct. Yeah.
Okay, so, but if they, pardon?
If it's not exactly, it's close. That's right. Yeah.
Well, that's what,
Right.
Mrs. Cox, I'm gonna
Yes.
trust your math a little bit on this, okay? You told me that you paid 7 months
Yeah,
of the
I
550.
could give you the exact, I would have to look at my app that has my receipts, but I can do
Okay.
that. Hold on just a moment. I'm sorry.
Okay, that's fine.
And just so your honor is aware, we did acknowledge 6 months when we filed the motion.
Right.
I actually don't know what happened this month on the $500.
Well, you have 500 or 550?
Well, 550, the 50 is for interest, so the credit is 500 per payment.
Okay.
And we knew that that would be the case, that over that period of time, you obviously accrued some charges that we knew it wouldn't be an exact science, but.
Mrs. Cox, what were you saying?
I have 7 payments that I've paid him. I have receipts for. The next one would be due the day after tomorrow.
Okay, but you have 7 payments of 550.
Yes, sir.
Would you agree that the credit to the 12,000 is only 500 and that the $50 is an interest type of payment?
I believe that's how the agreement was set.
How it works out. So that then gets me 35 credit to this of 3,500, which then brings, I come to a total of 22,350. I got it.
Take a look. My number's a little different and it may take me a second to parse it out.
Because here, just so that the parties understand sort of where the court's headed, if those payments have been made, they certainly get credit for that. And I'm trying to just have a firm figure that we're dealing with. And if I have 12,000, I have 13,850, I come to 25,850. There's then the 7 payments, which Mrs. Cox has indicated, which then, if I do my math, I get 22,350.
So, Yana, the difference, which is not large, is because when they did the agreement, which we contend is now null and void, they assumed the assessment would be 12,000, but the actual assessment that appeared on the rolls was 13,168.46.
Got it. Okay, so
And that is stated in Mr. Carroll's.
Your Honor.
13, that, hold on, Ms. Cox. I'll let you, I'm just,
Okay.
what appeared on the rolls?
13,168.46.
16486. Okay.
168.46, yes.
16846.
Yes.
168.46. Got it. 13,164.
168.
Give me the number again. 13,168 and 46 cents. Thank you. All right. Mrs. Cox, you were going to say something?
Yes, sir, Your Honor. I believe, and if I'm wrong, I apologize, but that 13,000 that was on the tax assessment also included the winter taxes, which are already rolled into my mortgage payment. So if I'm not remembering that correctly, or it's not itemized like that, my apologies, but that was a one line item, as tax. It wasn't separated out. I already paid that.
Okay, I get you. Is that right?
Your Honor, I would have to ask Mr. Carroll. May I ask?
Yeah, go ahead.
Larry, do you know what the assessment on your property in December of 2022 was based on the township work as opposed to regular winter taxes?
I am looking it up on the escrow. The winter tax is only like $800.
You're switching to that. Okay. Mr. Carroll, what do you have as the figure?
And I just, if Mr. Troika's cell phone was the one he talked to me on this morning, Township of York, in the December issued an assessment for $11,310.50 for the cleanup.
Say again?
There were two assessments that they added together. One was for 11,000, and I just texted Mr. Troika a copy of this from the township. $11,310.50 for cleanup, plus $975 to the township for court-ordered fine of $750, so that the fine that the courts ordered the Coxes to pay to the court, the township added it to my assessment. Attorney fees of $131.25 for June and $93.75 for July for the December 2023. The taxes were $858.06, which leaves a balance of all the assessments together, $12,310.
$12,000.
$310.40.
So, all right. So the assessment less the taxes was $12,310.40.
Your Honor, may I ask Mr. Carroll one question?
Sure.
Larry, did they pay $500 toward that assessment in September?
No, they started paying, no, September's payment isn't due for 2 days. So it was February, March, April, May, June, July, and August. So 7 times 500 is 3,500.
That's what I said.
But the number will be, is it the number 3,000 or 3,500 as we sit here today?
3,500 they have paid.
Okay.
Right.
And they're very diligent on these payment agreements. I got to give you that.
All right, sir, I don't need to hear that right now. Go ahead, Mr. Lilly.
Your Honor, I'm going to call into the township to verify numbers related to that special assessment. I have found the previous bill that was submitted in 2022, and the calculation that I came up based upon a sheet here that I have, which may or may not be correct, is $11,219.50. I'm trying to get verification from that from the township. If he's looking at his tax bill, okay, it probably has that information right.
Right. Okay, so here's what and I guess this is the figure right now that I'll work with, unless we see something different. That what Mrs. Cox has indicated that the actual assessment was not 12,000 as we were saying, but it's $12,310.40 was the actual assessment for the previous thing, and it included everything. And I'm going with plaintiff's numbers, Mr. Carroll's numbers on that. If I take that figure and then I deduct out $3,500, and that's great.
So from the 12,310.40 minus the 3,500 is $8,810.40.
Say again. 8,000.
Just make sure. $8,810.40.
Okay.
And I believe that the number that Larry gave you did include the taxes as well. I think he gave it to you. I could be wrong, but the way that I heard him, I think he said it included that.
No. He put that on at the end, but he had all of the assessments that came out to the 12,310.40. And then he said there was a separate amount for the taxes. Is that correct, Mr. Carroll?
That is correct, Your Honor. In December, my taxes were billed $13,000.
Okay, I don't need to know the taxes. I'm just saying
Yes.
$12,310.40 was the amount that was assessed less the taxes.
Correct. That does not include the tax.
Okay, thank you. That's all I need to know. No, it's okay. It's okay. So then if I take that 88,1040. And then the 13,850 and
13,850.
yes,
$22,660.40.
got it. 22,660.40.
Yes.
Thank you. All right. So whether we call it an assessment, whether we call it taxes to the property, I have a total amount of $22,660.40.
Yeah, I believe that to be correct. I'll also check the math while the court was doing it.
Okay. So Mr. and Mrs. Cox, you were saying to me, so there's this agreement regarding the first part, which you kept to, but you understand that the problem that I see here is that this needs to be paid. Okay.
I understand that. Right.
How would you look in getting that done?
Well, it would, I mean, if it were a bill in front of me that was due, we could not pay it.
Pardon?
I said, if it was like a current bill in front of me and that we had to pay, we could not pay that. So I don't know exactly what we would do. If, like I said, if that was a bill that I was holding, we'd have to discuss and figure something out. But it would be wounding.
Okay. So that you, and I haven't ruled yet, but I need the two of you to understand that. If I were to grant the relief that Mr. Carroll is requesting, then you would have 90 days by this court's determination. When I look at the figures, you would have a 90-day period to take care of that.
All right.
All right. I think in a certain respect, all right. And I understand the language that's contained in the agreement regarding the 550 payment, but in a certain respect, you made those good faith payments, and I get that. So I might have some leeway as it regards the 8810 and that payment, right? But the 13,850,
I think I see myself.
you agree with me? You know, I don't get that much, so I'm happy.
Well, no, I mean, it makes no sense that Larry would be on the hook for that or to arrange, you know, some payment plan for us. So I recognize that.
Okay, so now
To the side, I have some issue with it itself, and I'm not really sure how I would go about that.
with what?
Mr. Lillich say something about what he was required to give to us was an itemized listing of the charges associated with the assessment. And not on the first one did we ever see anything. And this time I saw a sheet of paper, and I'm not even really sure where I saw it, but it says cleanup, $13,850. So it's the part of this thing from an itemized listing. I didn't know that I was due one.
Okay, so
But it is
okay, all right,
arbitrary.
Mr. Cox, let me just stop you for a moment.
Sure.
Because you can make that argument if that's what you want to do. And I get the argument that you're attempting to try to make. That only goes to it being an assessment. Ultimately, this can be put out to whatever, because ultimately that's going to go on the rolls. And then I'm not even dealing with whether or not they gave you an itemized list.
Right, okay.
Okay. I get what you're saying, but I don't know that really gets you to really what the solution is.
I don't think it does either. I was just saying it to decide that it's something I need to investigate how that, or what controls the parameters of that, because it just seems to be the most arbitrary charge. And I don't know, maybe that's completely legit, but especially for something of that.
Okay, but Mr. Cox, we can, if you want to, we can have a full-blown hearing on that, if that's what you want to do.
No, it's not.
But hold on a second. I'm not sure that gets you there. Because let's say this, just hypothetically. Okay, we go through a hearing, whether the 13,850 is the correct number. And all of a sudden I maybe find in your favor and say, it really wasn't 13,850. It really should be around 11,000. Do you have the 11,000?
No, you're right.
Okay. So again, I don't know that gets you where you maybe want to be.
No, I don't think it does. I don't think it does either. I probably shouldn't even said it. I was just saying in my own.
Probably not. But
I was just saying in my own head, I'm just curious, like,
okay,
I don't know what I do with that.
Okay, Mr. Cox, let me just tell you, I try to just be practical as a judge.
Sure.
Okay. So the reality of this is you two want to stay in that home, correct?
We think so. Well, I mean, of course that is, there's been just so much. I mean, we've had some talk about, Larry's offered, or spoke to my wife about this buyer, and I'm not even sure of, what that is. So I mean that generally the answer to your question is yes. I mean,
Mrs. Cox, do you want to stay in the home? Is that what we're doing here? Or do you need, what are you looking to do? You're muted, ma'am.
There, I'm sorry about that, Your Honor.
It's okay.
I think since talking to Larry yesterday, it's just raised up some different options and everything with this proposed buyer with him. So I can't tell you that I'm 100% sure in what my wishes are at this moment, because that changed a lot yesterday.
Okay. All right, let me ask you two this and this one. As we sit here today, now knowing what you know, what would you like to see the court do? I'm not saying that I can do it, but what do you want the court to do?
Ronnie, you want to take that?
I don't even know how to answer that. I want resolution. I want some kind of resolution.
She just wants some peace. That's the truth. Yeah, I think that's what we want. We want, there's some kind of uncertainty that I think affects my wife even more than me, even though it does affect me as well. I think if we just know what it is, then we'll just know what it is. And
I hear you. And let me just say this. I think it's the same thing for Mr. Carroll. All right. So as I view it, I don't know that the parties are in a different spot entirely. You want to be able to say, okay, if we have to pay X amount more per month or whatever we have to pay, at least we know what we're facing.
Exactly.
Okay. Mr. Carroll, it's the same thing. And I dare even say for the township, but for Mr. Carroll, it's the same thing. He What he wants, which is why the initial agreement regarding the payment is set out the way that it is because he wants to know that every year or every 6 months or whatever, he's not facing this. He wants that same sort of peace of mind that you guys want. The township is not in the business of doing this. This is not what they're about. So they would like some peace of mind to say, we don't have to go to this property again. We don't have to go through all of these proceedings and get to the point where all of a sudden we've got to do some cleanup on the property. Then we got to go through the whole process of a court hearing and all of these things. They don't want to do that either. So then the question becomes, how do we get there? Because Mr. and Mrs. Cox, and I just by way of example, and I'm not ordering this at this point, but if I said, okay, you can pay the $8,810.40 pursuant to the payment plan, all right, that you guys had. All right, but you owe. But that the $13,850 has to be paid in 90 days. You can't do it. So what solution do you see to that?
I'm not sure that I heard. Did you say that if we kept the original, the first part was paid, and that the 13,000?
You've been paying the what's left of the 12,000 initial one. You've been paying that pursuant to this agreement, although there's an issue as to whether or not that agreement is still in effect. I mean, I get that. But so if I gave you credit for that, at least in saying they made an agreement, they're abiding by it, there's a part of it that they didn't, but in terms of the monetary amount, they're abiding by it. But maybe as the penalty for violating that agreement with regard to an additional assessment, an additional cleanup, an additional problem, this $13,850, you got to pay it in 90 days. You can't do it. Right?
That's what I'm not hearing. You can't do it? Is that what?
Well, that's what you told me.
Right,
If I told you you
that's
had
correct.
to pay the 13, okay. I mean,
It is largely correct, but I was saying.
well, Mr. Cox, you know, sometimes, especially when I'm dealing with married couples, I sometimes have to listen very closely to what's being said. Because you're telling me it's largely correct. Hold on. Mrs. Cox is telling me I'm correct. She's not putting any qualifiers on it. So here's what I'm going to tell you. I've listened to both of you. Both of you are great people. But on this one, I'm going with your wife.
I'm probably going with my wife.
What?
I'm probably going with my wife.
Why do you put qualifiers on it? She's the one. She says, "Look, I'm not gonna argue about who I believe, but in terms of whether or not it can be paid, if Mrs. Cox is telling me I'm correct that it can't be paid, I'm going with that because I think she's right."
Then I probably you're right.
I know. You're just talking.
Well, I know, but I'm just saying, you're asking a question, 13,000.
No, I said, I didn't ask a question. I made a statement. The statement I made is you can't pay it. You gave me a qualifier on that. Mrs. Cox didn't qualify. She said, you're right. Can't pay it.
Well, because it seems likely true.
Okay, you and your qualifiers. I'll just say this. Mrs. Cox, God bless you. All right. So you can't do it. So what do you see as a solution to this, folks?
It seems we will likely lose the house. I would assume in the event, I mean, would you, Laura, if
Yeah, I think
you're
that,
correctly,
Hold on, Mr. Cox.
yeah,
I will certainly let you go on, but right now, I don't want to hear from you. Mrs. Cox, what were you going to say?
I think that in the event that that was the judgment, that I'm very interested, and so is Patrick, in the possibility of looking at this buyer so that we, are able to fulfill Mr. Carroll's needs as well as our own and move on if it came to that, for sure. So
Mr. Troika, other than the 90 days, um, with reference to, I guess, the total figure really of the 22,660, is there any room to try to reach some agreement? I'm not asking for what that may be, but is there room to do that?
So, there's obviously a lot going on. A big part of our deal with the Coxes is external to us. It's with the township. The township has its own prerogatives. I don't begrudge them for exercising those prerogatives, but we can talk all we want amongst ourselves, like Mr. Carroll did back in January, and reach all the deals we want. If this issue with the township continues, nothing's going to work. I would suggest, I understand Your Honor is trying to be fair, which I appreciate. Your Honor always is, and I try to be as fair as I can while also being a zealous advocate. One option is to give us what we're asking for, put this on for a hearing date 90 days from today, and the court can assess at that point whether in fact the property is forfeited. If 90 days from today, the property is all cleaned up, the township is out of the picture, they didn't pay the full $8,000, but they paid the $500 a month and they paid the 13,850. Your Honor would be empowered equitably to not forfeit the property. I approach this from a certain degree of skepticism based on the duration of this case. And I suspect that in 90 days or 30 days or 120 days, the pile of junk is just going to grow and the township's not going to go away. So I would say for me, and I believe Mr. Carroll would agree, and to some degree, even the Coxes agree, the most important thing is forcing closure. That might mean they lose the house. Mr. Carroll is not even sure he wants it because we don't know the interior condition. He might get it. And if it looks in the inside like the yard looks, that's, it's a Pyrrhic victory. There is a buyer out there, potential buyer, and I suspect that if your court gave the 90 days, which I do think we're entitled to, it's going to force a lot of activity. And what I'm proposing is we come back, as close to day 90 as possible. So that way the court can avoid an unstoppable forfeiture. But we can maintain that and come back if we need to in 90 days and say, Your Honor, nothing has changed. We didn't get paid, or the property is still, the siding's not up, the property is still a mess, the township's breathing down our neck. That would defer to Your Honor the ability to make a decision on whether to extend the redemption period or what have you. That's my suggestion, given the complexity of the situation. What I want most from Mr. Carroll is a process that has an endpoint. And if the Coxes can't comply with that at all, and I suspect that's going to be where we are in 90 days, that the yard is full of debris. I don't control the township. I expect they're going to hold off on trying to get another order to clean up because they know that the effect of that is then the problem will just repeat. So I think if Mr. Cox, either through his own efforts or by getting Mrs. Cox involved or somebody involved, can take care of the township problems, chances are in 90 days, even if we have an order that theoretically would give us an expiration of redemption and a right to possession, Yana would have the right to say, nope, I'm, whatever, you're changing it, you're equitably extending it. I wouldn't be in a position to argue that. I mean, I could, but you have all the authority in the world to say no. And I don't think Mr. Carroll would argue it if the problem went away between now and then. I'm coming at this from the point of view that Mr. Cox has been given a lot of opportunities. There's still, before Your Honor this morning, a contempt motion against them because the problem, according to the township, which is visually apparent, is continuing. So that's kind of where we're at. The court's thoughts really are quite consistent with, I think, the Coxes and Mr. Carroll. The one difference is I think Your Honor has a bit of optimism. I really don't, I just don't from the history of this case. I think that unless Mr. Cox gets help and allows somebody to come in and control this situation, which he has not yet done, in 90 days, what you're going to see is a bigger pile of stuff and an angrier Mr. Lillick. Not that he's ever that angry, but still, a more persistent or insistent Mr. Lillick. And what am I going to say? I can't say the township can't enforce its code. All I can do in the next 90 days is say, please, Mr. Lillick, don't, because it would be counterproductive for both the township and Mr. Caro to come back in and try to clean it up again while we have this clock ticking. So my suggestion is order them to pay the 22 grand and change, which we came up with. Within 90 days, 13,850 would go to the township because we haven't actually paid it out of pocket. The order I prepared says you gotta, remediate the violations. You got to put the siding back on, which I don't think should be arguable. The siding's off. That exposes the property to water damage. There does appear to have been some work in the last couple of weeks or month or so on that. So hopefully that will take care of itself. And then this will give Your Honor the ability before a final expiration or redemption to revisit the issue. So that's my suggestion. And what it serves for my client is we got a clock ticking. And if my worst predictions play out and everything is worse in 90 days, then I think Your Honor would be persuaded to say, tough, you've lost the house. I mean, that's Your Honor's call, but I think that would be as reasonable as anybody could be to the Coxes. And we would also have going on in parallel a potential discussion about a buyout, which, that I think we all like that to happen, but we can't control that either because it involves a third party.
Mr. Lillick, with regard to what needs to be done to the premises, there's the siding issue. Is that the siding issue? Is that fundamentally it? That needs to.
Siding issue and, the fines and costs haven't been paid. There's a new accumulation of junk on the property, Your Honor. There's a picture attached to the motion that I filed that was taken the day before I filed the motion on August 17th. I have pictures since August 17th showing that there is frankly more accumulation on the property. I know that the last hearing, Mr. Fox indicated to this court that we didn't clean up the property properly. That's not true. I have a video that shows the status of that property on the day of the cleanup back in July this year. I have Mr. Toth, who's here, who affirms that in fact it was cleaned up. And then again, Your Honor, we're back here again with more junk on the property. I will tell the court that, this case was first before this court, you, Your Honor.
I know.
Okay, all right. There was a judgment that was entered back in 2019. It went to contempt. He finally did clean up the property. A second case was the 2022 case in front of Judge Freshour. It didn't clean up, which resulted in the $12,000 plus assessment on the property at the end of 2022. And now 2023, Your Honor, again, we're back before the court with a new violation. And unfortunately, after being ordered to clean up the property and fix the siding, which is atrocious on the property, it looks terrible, Your Honor. The township was again, forced to go onto that property and clean it up. As you are absolutely correct, Your Honor. The township isn't in the business. The township doesn't want to do this. It is a very, very rare case in which the township actually has to do it. And it's happened twice with the Coxes, Your Honor. So I agree with Mr. Troika that this does not seem like it's going to end by some type of compliance by the Coxes. It's with respect to the ordinance violation, Your Honor.
How much fines and costs how much are the fines and costs that haven't been paid?
Well,
do you have a total?
Haven't been paid at the 13,000.
You're gotcha.
Exactly.
Okay.
$13,850.
I thought there was another figure you were talking about.
And that includes all the costs up to this stage, Your Honor. Although we're here on a contempt show cause, Your Honor, I would be requesting additional costs on a finding that they have not done what they're required to do under the ordinance. I believe I'm entitled to. So again, it's unfortunate. Okay. You know, nobody wants this problem for them, but they're not taking care of it, Your Honor. That property looks awful. It looks trash. You can take a look at the picture that's attached as an exhibit. You can
I see it.
Site, Your Honor. That was a cited property. Okay, I don't know what happened to the siding. It's just it's
I do.
suspected that it came down and was what?
If in all of the orders, the word replace, or I mean, to reattach all of the siding. This issue, we've discussed it numerous times. Tom took all of the siding. I had all the siding in the backyard. It was all laid out. I took it all down because it's only on one section of the house. See, I think that this is where we really change paths, because the tenor of this is it makes it out like I'm just this horrendous thing, and that my house is atrocious. It's one section of the house.
Okay.
That's missing the siding, and it's because I took it down. I insulated the wall. I power washed all of it in my backyard. It was laid out in lengths and by cut angles to the gable. Tom took all of it and put it in the dumpster, and he thought that was humorous. So in all of the things that say to rehang the siding, it actually can't be accomplished because it's not there. Now, to re-side it, put up new siding, can be done. I've purchased that. That actually should not have been a charge that I had to assume, but I did get it. I have not put it up yet, but Tom took it. He took all of the things in the backyard, including my trailer. I bought a trailer to comply with this. John, please, if you could just give me a moment. There's
That's how that works? Okay,
What's that?
yeah, no, go ahead. Keep talking. Your Honor. No, let him go. Because he wanted me to give him a moment, so I'm gonna give him a moment.
If it'll hurt me, I guess I won't, but Mr. Lilich just spoke at length. I just wanted to say that my attempts to comply have been interrupted numerous times from Tom, and it doesn't mean that I can't have it done, but it's just fair to paint it the proper color, and that's the proper color.
Okay, let me get away from the siding for a moment.
Your Honor, if I just might.
No,
Okay.
just get away from the siding. Where does all this stuff keep coming from? I'm presuming it doesn't have its own legs and just walk into the property and sit there. Where is it coming from?
I go out and I collect it, dumpsters and different places that discard whatever. I sell a lot of it, and I do a lot of metal scrap. So I take it back to the metal yard.
You're a scrapper.
That's right.
Okay. So Mr. Cox, give me an honest answer. You're bringing all of this back. What's your wife tell you?
She doesn't like it at all.
Yeah. So, not here to get into all your business, but if she doesn't like it, why are you doing it?
I think I may have mentioned this the last time in court. It's just true. It's something I obviously need to get away from. But at the start of COVID,
That's not my question.
No,
That's not even an answer to my question.
but I'm
Mr. Cox, Mr. Cox.
I'm trying to answer your question.
No, you're not.
Yes, I
You're
am.
trying to give me an excuse.
Oh, I'm not, Your Honor, at all.
Oh, you don't want to take that attitude with me. I'm going to ask you a direct question. If your wife is saying she doesn't like it, why is it still happening?
Because it's the way that I can best contribute to our financial life. I lost my job at the start of COVID. Respectfully, Your Honor, this is what I was going to say. And I felt carried by my wife, and I felt a certain level of shame associated with that. And I found a way to contribute, even though she still carried the bag. I was in the game, and I needed to be able to be in the game.
Okay, let's assume all of that is correct.
It,
But hold on. Every time these assessments come up, you're going out of the world backwards.
I'm aware of that. It's a failed.
Well, but hold on, Mr. Cox. I mean, in some respects, I may not even be talking the law at this point. You're going out of the world backwards. Meanwhile, this person who, as you put it, is carrying the bag is just trying to hold things together.
So,
and I'm going to tell you what my thought process on it is right now. You're not helping. At all. Your behavior in doing what you're doing to try to correct it is just making things worse. And I think the thing that maybe you are appreciating in all of this, and I can appreciate sort of the ego trying to make sure I'm providing and whatever. Through all of this, she's told you she doesn't like it. But you know what? She hasn't gone anywhere. She keeps doing what she's doing.
she's my wife.
She's probably a whole lot more than that. I don't know Miss Cox, but I've listened to her. And I get she's a whole lot more than that.
I certainly didn't say that in a limited capacity.
Let me just tell you what I'm thinking, Mr. Cox. I realize you are trying to do what you're doing. The only hesitation I'm having from just granting all of the relief that the plaintiff wants, as well as the township may want in this case. Do you know the only thing that's preventing me from just doing that? Because I can just rule right now. What do you think is preventing me?
Probably my wife.
Absolutely your wife. Like I said, I don't know her. I've just been watching her on screen here today, listening to her. And I am trying my best to not do something that creates absolute disaster for her. I've sat here and I've listened to you. I don't think anybody can say I didn't hear everything anybody said. But I don't think you realize how lucky you are, because if she was giving me all the figures, she's telling me everything that needs to be done. If she weren't here, this case would have been over an hour ago. So maybe, Mr. Cox, what you've got to figure out is how to stop disaster for your wife from happening. Any thoughts on that, Mr. Cox?
I have a lot of thoughts on it.
Any you want to share?
No. I don't mean that in any negative way, but just know that, you know, I find it personally.
No, I got you. Mrs. Cox,
Yes, Your Honor.
I know it's a hard question. I kind of asked it before. What do you want me to do?
If you're considering honoring the motion and doing the forfeiture, I would just ask that anything with the township be paused, including contempt or anything else for this 90-day period. Pat does take care of his dad, and he's not going to do any good for himself, his health, or anyone else if he's held in contempt. And we will do our best to comply. He has started working on the siding. We will do our best to either comply or to work with Larry on a prospective buyer.
Let me ask my question in a slightly different way. Ms. Cox, you all right?
Yeah.
Okay. Taking out the what I would do and then how you would respond. So what I'm really asking is, what do you want to see happen today? What would you like me to do? I'm not saying that I'll do it. I'm just saying, what would you like me to do?
Well, I mean, I don't know what to do about the $13,000 judgment. So I would like somehow that not to be over my head, because we've been paying the rest. I don't know that I've gotten, like I said, everything changed with the offer yesterday. I just want peace. I did talk to when Judge Freshour had us the last time. I did speak and say that, you know, Patrick was very vocal with me that he understands that his need to provide sort of spiraled out of control over the past few years, obviously. and that he is aware of that and is taking steps. His physician has made referrals. He's seen one person. He's waiting for a urgent referral over to see another person that can help him kind of work through a lot of that. So he has taken steps to say that he knows he doesn't want this kind of life for his future. And whatever they call that, I don't know. I'm not a professional, but I'm very proud of him for doing that. And I certainly understand why he did that, especially being a nurse, because I think a lot of people's lives became disrupted by the pandemic. People handled that in different ways. Some maybe are still handling it, such as himself. And, you know, I think if you have people that support you and are in your corner, you can get through it if you can admit. And he has admitted that, you know, he did get out of control and needs that help. So I think that, again, putting him in contempt or anything like that is not going to solve the issue. And in fact, may make things matters worse. All I can tell you, Judge Simpson, is that Patrick's a good man who's just kind of found himself lost, but he's a good man.
Ma'am, I don't doubt that one bit. But sometimes, and I guess we don't admit it necessarily about our partners in life, I think he's a good man. I think at his core, certainly he is. But I think there's somebody in his life that makes him a better man. So I get it. And Mr. Cox, you okay?
Yeah.
All right, look. Part of really what's happening here, and I'm just going to kind of be blunt, is you're dealing with some things, Mr. Cox. Mrs. Cox is sticking by you in terms of dealing with it. And, you know you're blessed by that, but I don't think you even understand how blessed you are by that.
I do.
And so the manifestations of what you're dealing with, which are resulting in these behaviors of continually sort of adding to the property. I think I have a much clearer picture of what's happening. That's why it continues the way that it does with you. So, yes.
Like, might I just suggest to the court, okay? I mean, I think the picture's clear what's going on here to a great extent. I would suggest to the court that the court's contempt powers are broad, okay? And under those powers, potentially have control or can make orders that are necessary to try to remedy some of these issues. They don't have to necessarily be to Mrs. Cox, but I just offered that, Your Honor, as a possible suggestion. The court can always appoint a receiver in this upon finding of contempt also. So I just offer that Your Honor has a lot of power.
Oh, I Believe me, I understand that. Um, Mr. Lilick, I appreciate what you're saying, but the bottom line to everything, yeah, we're dealing with a piece of property, we're dealing with cleanup, we're dealing with all of those things, but at the bottom line of everything, I'm also dealing with human beings. And I'm going to tell you what I say, and I'm just going to be sort of cold-hearted and blunt about it. Pandemic comes, Mr. Cox finds himself in a really difficult position. He's struggling, and I'll say psychologically struggling, to try to pull himself through. I listen very closely to what Mrs. Cox is saying, why she's there. And I'm going to put it another way. And I also realize the contempt powers I have, I can use them or not use them. But appreciate what Miss Cox is asking. And I'm just going to put it another way. She is just asking, out of everything. She's potentially about to lose her house. Everything is just going where it's going. And really, in everything that she said, she's only asked me for two things. One is, and I'll just say she's amazing in this regard, because the first thing that she asked me for is just peace. She needs, which I took as at some point for her, she needs to take a breath. But I think the other thing is probably a lot more important that she was asking me for. And what she was asking me for is, and she doesn't want anything contempt on Mr. Cox, because really, as a wife, what she's asking is, don't strip my husband of any dignity that he's already thinks that he's lost. Mr. Luck, that didn't come from out of some law book. What she asked me was just out of pure love for him. Court's going to stand in brief recess. I'll come back and give you a decision on this.
Your Honor, can I make one comment? I think it may be relevant, and I may be wrong. I thought this original case came before you in 2019, which was brief. I just want to put on the record that if that's true, then the narrative about this being COVID related falls apart. So I say,
no. The original case came there, but I don't know. I'm leaving the bench. So you can keep talking if you like, but I'm leaving the bench. Court stands in recess.
Thank you.
All right, you may be seated. We're back on the record in York versus Cox, as well as Carroll versus Cox. Here's what the court's going to do.
I saw you take it down.
Thank you. Did. Let me just say at the outset, and I say that this at great risk, but I'm going to say it anyway. Ms. Cox,
Yes, Your Honor.
sometimes people come into courtrooms and sometimes they believe that they're not heard. I want you to understand you were heard today by this judge.
Thank you.
Loud and clear. I wish the ability to grant peace came with this robe. It doesn't. Maybe sometimes through these proceedings, I can facilitate certain things that can get you there. But I think if I had the absolute ability to grant peace, I'd just be signing that order all the time. But I can't do that. Sometimes to gain that, I think, though, you just need to be able to breathe a little bit and we figure it out. Right?
Yes, Your Honor. Yes, sir.
So the court has decided to do today is I'm going to grant a judgment subject to the court's review to Mr. Carroll for forfeiture. The redemption period, the court is even at this point going to extend to 120 days. I will set a review hearing on the matter for November 14th, 2023, 9 a.m. in person. As part of the redemption, the total amount will be the $22,660.40. The $8,810.40 of that will be paid as the parties had agreed at the additional $550 per month. So those payments will continue throughout any period. The other amount will become due. The court is reserving the right to extend the redemption period in accord with the court's equitable powers to do so under the circumstances. With regard to the citing, I am going to order that the citing on the premises is to be up prior to or be the November 14th, 2023 date. You understand that, Mr. Cox? The more, well, it is part of a difficult issue, but I'm going to address it this way. Mr. Cox, you are not to bring any more materials or scrap onto the premises. All right. You understand that, sir?
I do.
Without saying it directly, because again, sometimes everybody's business doesn't need to be thrust into the world. I have a pretty clear, or at least somewhat clear understanding of why this is happening and why certain behaviors are occurring. I will offer to the Cox, and I'm not saying that you have to, but I understand that Mr. Cox is making a journey in terms of seeing people and talking with folks. All right. Um, whatever medical or evaluations regarding that the Coxes would like to provide to the court, you may do so. If you provide it to the court, you can provide that under seal, meaning bring it to the court. If there's something you want me to see and take into consideration, in a sealed envelope, tell them that this is get directly to me. I will make a determination as to whether or not it's shared or would issue a protective order so that it cannot be shared, so that I can take a look at it. I realize there are things, some of which are of a psychological nature, most likely. Put it that way, that may be going on. And the more information I have regarding that, probably the better off we are in terms of the court trying to reach a fair and just resolution of it. You understand that, Mr. Cox?
I do.
Mrs. Cox, you, and I know you're a nurse, so you understand what I'm saying.
I do. Thank you, Your Honor.
With regard to any type of contempt, and Mr. Lilick is right, the court's powers are very broad in that respect. And at this juncture, any type of request for contempt or anything along those lines, the court is going to decline to exercise those powers today. Will adjourn that, any type of proceeding regarding contempt, to November 14th, 2023. That hearing. I'm doing that because, and just so the record's clear, I think certainly the court can issue orders of contempt, but sometimes also prior to doing that, the court also has to find mercy in its heart for certain things. The plea of Ms. Cox not to issue a contempt order, and it was interesting that she picked that out of all things, is because she does not wish to have Mr. Cox's dignity completely stricken. And this court wholeheartedly agrees with that. And I'm not going to be a part of that at this juncture of these proceedings. I need to see more before I would venture down that path.
Thank you, Your Honor.
You're welcome, Ms. Cox. Are there any other questions regarding the court's decision?
Your Honor, did you address the cleanup of the property at this point, or
The new things that are coming on?
stuff that I heard you say that no more stuff on, but the current status of the property is that there is a bunch of junk on the property at this point, so it needs to be removed and resolved. Township prefer not to have to go back on the property and do it, but
I don't have a problem ordering that. But what I also know is that if I order that creates a greater struggle. And, you know, folks, I'm just going to lay it out this way. And I'm not saying this to embarrass Mr. and Mrs. Cox at all. We're dealing with certain psychological issues. that can only be taken in certain steps. And so part of that's going to be not, I'm trying to take, I'm not a doctor, I'm not a psychologist. I mean, I'm trying to take that in steps. One of the first steps really is going to be, at least in my opinion, and just my best guess, educated guess at it, is to not have any more come on.
Your Honor, with that regard, then would it be appropriate for us to go out there, go onto the property and take good pictures today or tomorrow so that we got a status quo?
That's fine. Take photos so that we know that that's not occurring and that Mr. Cox would be complying with that order. Any other questions regarding the court's order?
Your Honor, is this something that you want one of us to prepare and submit to the court?
Yes, you may do that, sir.
And a couple of questions. I want to make sure I have this right. The math, 120 days from today is January 10th. And I'd like to put it in running from today as opposed to when the order is entered. So I'll put a hard date of January 10th.
Correct.
Otherwise, I understand that the 13850 will be used for the end of redemption. Obviously, on November 14th, we'll have a conversation about the current status of things. Mr. Carroll lives in Kentucky, so if it's okay with the honor, I would ask him to appear by Zoom, and I'll be here in person.
That's
And I would like to put into the order, if your honor will bless this, that Mr. Carroll has a right to inspect the interior upon notice. I don't know if the Constitution would agree, but if there's going to be any parallel discussion about a potential sale,
great.
We don't want to just show up and knock down the door. We don't have the right to do that. We could be out, and I think in Ann Arbor, it's like 48 hours, 48, 72, whatever. I'd like to stick in a provision that we can provide notice, come and take a look, document the condition on the inside because it's either good or it's bad, and that's going to make a big difference in how this plays out.
Gotcha. Mr. Cox, you have any issue with
No,
the interior inspection?
no.
All right.
Oh,
Mrs. Cox, how much
No.
time in anticipation of an interior inspection would you need?
I'll leave that to Patrick because I've been traveling out of state much of the time for work.
Okay. 72 hours notice.
We'll do that. And it may get my email. Mr. Carroll has I think as John may appreciate it, he's able to talk to the Coxes. I don't think this would be conflictual. We just want, whether it's, 3 days or 4 days, whatever, the ability to see, because that makes a big difference in where he comes out this and the ability to sell the property. To be clear, the 550 would be as previously treated, 500 applied against the assessment, 50 would just be interest. And then I didn't quite follow through, but we are not at this point going to include the provision that the current scrap on the property be removed within the redemption period, or would we put that in? We could.
Correct. What I'm indicating is that there's to be no more materials.
No more. All right. And then we do have pictures from yesterday, and I understand the township might go today or tomorrow and document, but we have a pretty good baseline as things stand. And to be clear, Mr. Lillard, you need to go onto the property or do it from the road?
No, I think it would be appropriate to go onto the property and take good pictures of everything. Doing it from the road gives a perspective that, may or may not be accurate.
The township has the right to order to enter the premises for the taking of those photos.
Okay, and I'll put that in the order, but it will happen before you get the order and enter it. But I don't perceive there's any objection. This is just an outside inspection, right?
Right. Now, if I could just ask that someone get a hold of me because my dogs.
Okay. Just
They're gonna come.
somebody let him know. All right.
And then we'll have the in-person subject to Mr. Carroll will be by Zoom the 14th at 9 a.m.
Correct.
You want that in the order, or would the court issue?
You can put it in the order.
Okay. Okay.
All right.
I think that I know I have more questions, but that's all I can think of now.
All right. Mr. Cox, do you have any questions?
Thank you.
Mrs. Cox,
No, Your Honor, thank you.
you don't have any questions?
No, sir.
And I'll just leave you with this, Mr. Cox. I think you understand how blessed you are. Mr. Cox,
I do.
you know, out of all of everything that was going on, a lot of heavy issues, kind of just let your wife talk. And what she said in very few words was a whole lot of things. Just mountains of information in just a very few words she was speaking. That's one of the reasons why you're blessed. But the other thing is this. Despite all of the difficulties and everything, she could have, may not have been able to provide it, but she could have asked me for the moon. She didn't do that. She just asked for peace. Right? She asked that you not be held in contempt for your sake. Right? And then through all of it, the one thing that she wanted me to know, and it didn't fall on deaf ears, is that you're a good man. I may not trust anybody in this courtroom. For whatever reason, I trust her. And if she told me that, I'm going to believe it. And I need you to act in accord with that. Understood?
Very much.
All right. Thank you, folks.
Thank you.
I will send you that shortly.
All right. Here, I wrote nothing. Shocking.
Yeah, I know. Hurry up and get to the good part. You've been watching this for 2.5 hours. You want to know what happens next. I don't blame you. It's pretty good. So, there was a November 15th, I think, 17th hearing, middle of November, which was about a week after the Washtenaw County Courts, 14A, Judge Simpson, stopped live streaming. So we have no idea what happened at that hearing. Did it happen? Did it not happen? Looking at the docket, it was continued to the first week in January. January 7th, 9th, somewhere on my calendar. Assuming that they probably knew that there was stuff accumulating. Again, they were giving them time to figure something out. Something along those lines. Because the person who was driving by, checking things out, taking pictures for me, sent these. And as you can see, things are starting to accumulate again. Same things, same spots, everything's all the same, looks the same. We're going right back to old habits. Obviously, there's an issue. So I was waiting until January, figuring, okay, they're probably going to take some major action. They're going to assess these fines to the homeowners. The homeowners are going to end up losing the house and all of the money they've paid into this, all the equity and everything else. This is going to be a huge financial hit for them. Then all of a sudden, I see this on the news. I read the Detroit news because, in Florida, we need to know what's going on. Up in the north, it also helps me find cases. And I read about this story of a fire. And it's strikingly familiar. And it takes me a minute. And all of a sudden I realize, OMG, that's the Hoarder house. And the local people call it the Hoarder house. I didn't give it that name. The local people did. And on January 16th at 4:18 p.m., Saline Area Fire Department was dispatched to the Platte Road home. Multiple people called 911 to report a home was fully engulfed. The firefighters were on scene within minutes. Milan, Pittsfield, and Augusta fire departments had to provide aid. Pittsfield utilized its tower truck to attack the fire from above. DTE was requested to cut power and gas. All residents of the home were out safely. One patient on oxygen did require oxygen from EMTs. At 4:40 p.m., firefighters reported that ammunition was going off inside the home. Most of the non-saline units were released from the scene at 7:40 p.m., so it took about 3 hours, and the saline firefighters continued to work on the scene until 11 p.m. Yeah, it's gone. There were some colorful comments about the house on the Facebook post. Initially, it was reported that all of the animals were out of the house. I know you can see in one of the Hoarder photos that there's a dog sitting in the yard. They did have quite a few animals. There was a cat reported missing, but that has been retracted from an updated story. So I'm assuming all pets and humans are safely out of the house. But this leaves quite a conundrum because the people living in the house were not the owners. They were technically renters as far as insurance would fall. So did they have renter's insurance? The homeowner will probably be made whole minus the assessment fees, but he has quite a bit of equity in the home. But what's going to happen to the homeowners? Wow. Not the ending I expected in this situation. And lots of insurance fraud accusations being thrown around on Facebook, which it is kind of ironic, everything going on, you know, all things considered. But when you have that much stuff in an old house that's under construction, and it's easy for things to go wrong. It's tragic. His family just lost everything right before the holidays. Be thankful for what you have, people. You never know what tomorrow is going to bring. Have a good one until next time.
And here come these guys. Lawrence Caro versus Patrick Cox. And I'm calling the civil matter, which is case ending in 399, as well as all of the cases or the zoning violation cases ending in 2503, 2504, 2505, and 2506. Council state your appearances.
Good morning, Your Honor. Dan Schweikert, here you have plaintiff Lawrence Caro.
And Victor Lillich on behalf of York Township.
And the Coxes are present.
The Coxes are present. I did receive some information that I don't know now where this stands.
Yes. Your Honor, accused as well. There was a request from the Coxes last week, during 6 weeks. I was not in the country and wasn't able to deal with that request, but I think it's smart to proceed with the review here today, precisely because this is a unique and messy situation, and we at least want to have that review and see what happens. As Your Honor might recall, back in September, on my motion for summary disposition before entered the foreclosure judgment, that had certain requirements involving siding and cleanup. In addition, what's most material to me today is that tomorrow, the Coxes are required to pay $13,850 under that foreclosure judgment. And if they don't, the redemption will expire. So we're up against a clock there. We think they should pay the $13,850. It is a court order. It's important to Mr. Caro. Mr. Caro has been cash strapped by the situation. John, if I recall, because of half the assessments by the township, he had his own mortgage payments skyrocket, and now he no longer has the spread. He's got to pay out of pocket every month a significant amount of money. So we're requesting that the $13,850 be paid by tomorrow, and if not, the Coxes lose all interest in the property. Now, what John might be referring to, and it's public knowledge, even if it wasn't, you have seen email from Wisconsin. On December 16th, there was a house fire. So the house at issue in this case was destroyed. As I understand it, it's a total loss. And my client has submitted an insurance claim with this carrier and an insurance claim with the Cox's carrier because they had used an additional insured, which is a requirement under the land contract. I want to note in the email from the Cox's, they said that the carrier requested an investigation of the fire. Well, that would be within his rights if he wanted to. He has not. He has no reason to make any requests. That's not his decision. If there's any investigation, it would be from authorities or from insurance companies. We do know that insurance companies are doing cause and origin investigations because they always do.
Residential fires are a lot more common than people think. We hear about them in the news a lot. I mean, for example, there was a lot of storms that went through the area last night. Well, they went through like half the country, but Florida was really bad. There was like 4 or 5 different fires all at the same time. just in my general area. The U.S. Fire Administration, which looks to be a division of FEMA, you can visit their website at usfa.fema.gov, has a ton of statistical information on their website. As you can see, in 2021, there was over 350,000 residential fires. But even more interesting is the causes of these fires. The majority of the fires, by far, are caused by cooking, with some caused by heating, some electrical malfunctions, and the others unintentional carelessness, which could be so many different things. But the number of cooking fires is shocking. We don't know what caused the fire at the Cox's residence, and I'm sure there'll be a very detailed investigation to determine why. It's pretty interesting to know. Be safe around your stove. Just a few quick tips, to keep us all around, because I don't want anybody to lose their house or anything. The number one cause of cooking fires is leaving them unattended. So don't put that pot on the stove and then go back to finish watching your YouTube video, because if you're like me, you'll forget that pot's on the stove, and that is what causes cooking fires. Another thing is to keep any kind of fabric or material away from the stove. That is another huge cause of fire. Whether it's you wearing a big old shirt or throwing the towel on the stove and not thinking about it, that's another big one. And if you do have a fire, if it's a grease or an oil fire, you can put a pan lid or turn a pan upside down and put it over top of it, because if you smother it and keep the oxygen away from it, that is one of the ways to put it out. Don't ever use water. Don't use flour either. A lot of people think you're supposed to use flour. Do not use flour on a cooking fire. You want to put baking soda on it. That's one thing that will take care of it. Also, get a little fire extinguisher. Keep it underneath your sink or something. They make little small ones. And if you do have a fire extinguisher, check it every so often. Check your smoke detectors too. People don't think about that. They take it for granted. And then when something bad happens, yeah, you'll regret it. Don't regret things. Fix it. Fix it, fix it. Don't have a fire. It's bad. Watch this. It's bad.
Speculate on what they want to do, what the outcome will be. What we'd like to do is have the cops state what the court determined is due by tomorrow. Mr. Carroll has been living this nightmare now for close to a year, and we'd like to see the cops fulfill some of their obligations. At our last hearing, November 14th, John, if I recall that time, the cops had been ordered to replace siding on the house. They had not done so. That was a violation of court order. I acknowledge today they can't do so because the house burned down. There have been several orders from the court on that. Township, the consolidated cases to clean up, and they had partly done so as the last hearing, but not entirely. There's still actual debris out in the yard, but I think the circumstances have changed. So we're in a situation where I do genuinely want to hear from the Coxes. We don't actually know for sure what the plan is based on the email they sent to your Honor's chambers. It appears that their plan is to proceed with an insurance claim and use those funds to pay out my client and a deal with the neighbor named Zach Mounsey to buy this property. With Mr. Mounsey, this was again signed in the email sent to the court. There had been discussion about him buying the property. I assume he's still potentially interested. He owns all the surrounding property, so we think he's a motivated buyer, but he wants to fill in a gap and have one large parcel, which he can't do until he gets his property. There were some comments about what Mr. Carroll had said to Mr. Mounsey in that email on January 2nd. And I want to be clear, what we said to Mr. Mounsey is if you pay us, if we are paid at a closing what we are owed, which does include my fees, then we have of course we'll cooperate with legal obligation in those circumstances to tender a deed and discharge land contract. And none of that's happened at this point. Mr. Mounsey, as far as we know, has not, he never did agree actually to pay 100 cents of the dollar. There were negotiations, but no agreement at the moment. Now Mr. Mounsey has said, understandably, that he's not paying full price for a home that's been destroyed. So I frankly don't know what is going to happen. And as we're looking for a way out, we think the Coxes should pay or order them to pay back in September. If so, they'll take care of one major issue, and then there will a necessity be an insurance process. don't know how that will play out in the consequences. Mr. Carroll independently has a right under both his own policy and under the consequence policy to be paid. So we assume he'll be taken care of, but there's going to be an adjustment process. And, Your Honor, I have, as Your Honor knows, I've always been here on messy situations. This is one that I'm in a bit of a loss.
Yes.
It's unusual.
Let me just ask one question. There's the probably shouldn't, but I want to make sure that if the Coxes pay that amount, or if they don't pay that amount, and their interest in the property is extinguished, does that foreclose another avenue of payment to your client, which might be their insurance?
Yeah, it's a fantastic question, one that I have thought about on my travels abroad and have not had time to find an answer. So there is.
No, that's fair.
My position will be that because Carroll is insured, that if the Coxes were to lose their interest in the property, he could stand in their shoes and be entitled to full replacement costs. I do understand that at least his own carrier is going to indemnify him for the actual property, which is less than full value because the Coxes have equity in the property as of today. So it's a very complicated situation. I'm sitting here asking the court to award certain relief. I don't know for sure that won't back on it. I mean, it's just genuinely a complicated question. I have dealt with insurance cases involving a mortgagee policy and a owner policy. And there's a famous quote by a federal judge: "The only thing worse than having no insurance is having two." And this is potentially one of those situations. But we're looking for something. There is an existing court order. We think it should be followed. If it is, then the Coxes will be buying time to sort out. I will say our end game is one of two things. The first is our legal right is to be paid in full. And that's whatever's owed to the land contract. And the local state, the Coxes have been paying monthly payments. They may have been late 1 or 2 days, but set that aside. They have been paying monthly payments. As John might recall, there was the land contract installment plus $550, which is payment over time on a past assessment for the township. Or if the Coxes don't pay the $13,850, we would buy an operational law, be the sole owner of the property. Maybe we get paid the replacement cost from the policy. Maybe we don't. We'll find out. Those are issues that are just too early and don't have a crystal ball, don't know how to play out.
Mr. Lilick, anything?
Yes, Your Honor, just so the township, or so you understand what the township is and what we're doing here, frankly, Your Honor. I mean, we had a judgment in this case back in May for long-standing blight beside the property. Hearing sometime in July, we didn't comply with the review hearing at that time. So we brought the motion for contempt. That's what's before this court. We had a review hearing in September and in November. In the review hearing in September, this court entered an order that basically said, don't bring anything else on the property and do what the prior court order said, which was to reside the property. As pointed out, there's been a fire now, so the siding of the property is not too much of an issue at this point. However, there is still blight on the property, and I have evidence because we did status quo pictures in September of what the blight was on the property at that time. It was increased in November at the review hearing from pictures that I had, and now substantially more increased from pictures that were taken yesterday. So, Your Honor, again, townships, this is a contempt proceeding. All along, we've got no compliance whatsoever with any of the court's orders in this case. I'll just tell you that, you know, we have a claim on that property also at this point, of course, because the insurance. We eventually are going to get that property cleaned up, Your Honor, in part probably by the insurance that's on the property. That's what our expectations. I don't know that for a fact right now, but that's what the expectations. So we're going to become whole at some point in this process. But I just want to point out to the court that what we're doing here is for contempt. And frankly,
No, I know. I know why you're here. I guess the issue is, and I will tell you, I'm a little bit reluctant to take any action for any failure because I'm sure there are going to be insurance investigations going on. Some things may not need to be touched at this point. So just so that you know, it's not my reluctance to act. It's just.
I understand, Your Honor, but I just wanted to kind of make sure that we were all on the same page. So.
And the Coxes. Tell me what you want to know. You can come forward, man. State your name.
Laura X.
Yes, ma'am. What would you like to tell the court?
I did send you the letter last week, so. I keep paying people tomorrow. We've lost everything we own. We've lost everything in my children's lives. Anything that was passed on to me through family, and we're living in a hotel. We have paid every payment that's been due. And we had a dump on the property the day of the fire that had us hold up. We met with the investigators this week. It's finally moving to where Patrick's gonna help them do a blueprint type drawing of the house, but I don't know how I pay tomorrow when I'm living in a hotel. And I mean, he's wearing a dead person's clothes because he had the clothes on his back. My father-in-law, thank God people got out. We lost one animal. But we want this to go away too, more than you can possibly imagine. And Mr. Mousy, I don't have a printer and it didn't come until after I left work last night. But Patrick and him met yesterday. We do have a new letter of intent that I can forward. Certainly it won't, the number is not in there for the cost because it will be for the property minus the house. And I'm sorry.
Okay. Okay. So what I've heard from everybody, stay temporarily my order regarding the payment. And I'm doing that because I think it would be either by operation of the order or otherwise imprudent at this point, not knowing everything for that to take effect. I don't know what implication it has for the plaintiffs, the defendants, or the township, particularly regarding any insurance.
Just a clarification. I assume the monthly payment will still be paid. So we're
Never not paid.
I'm not confused. I just want to make sure that we're talking about.
You're gonna, right. I'm just talking about that larger payment. I'm not, the monthly payment would continue.
Employed still, so
Pardon?
I'm still with my job, so we're still gonna pay our payments.
Okay, very good. All right. I don't know how long these investigations take. So, and so I'm guessing. I'll tell you folks, I'm just trying to figure out, and I presume it's going to depend on what they see where and everything else. So my inclination is to adjourn this out to, what's today? What's my February date?
February 6th or February 13th at 9 a.m.
I think I'd like to send this to February 13th, if that works. Give it basically that time frame, not a large time frame, but then we can take a look at where everybody is at that.
February 13th.
Yes,
And what time?
9 a.m.
Yes. Thank you.
Okay, so the monthly payments will continue. The other part will be stay. Yes,
I have an issue with 13th, Your Honor. I have a.
it's okay. We all didn't want you here anyway. No, go ahead. What?
I understand. And frankly, I don't think the township's position is going to change at this point too much, Your Honor. We have a lien on the property at this point, so.
Yeah, I don't know that anybody's position is going to change until such time as we hear from the insurance companies and whatever. I mean,
Is February 20th available? I
20th is not.
I'll make it work.
All right. So we'll do the 13th. If it looks like, and feel free to write to my office if you do it by that Friday. It might be that we're in a position where everybody shows up and we can't do it, or I wouldn't do anything anyway. And so there might be an agreement that we don't need that date and I can give you another day.
And one additional question, does your honor need it to be in person? I have no issue coming to the court, but
If you fill out a form, then I can do it all by Zoom. And do we have them in here?
Not in here, no, but it will be in the when that goes out, and I can send it to you separately as well.
And Your Honor, just so the court's aware, I'm probably not going to be able to make that hearing at 9 o'clock, okay, at June, otherwise, because I have a meeting that I have to.
Okay, that's fine. That's fine. Either way, whatever's going to be most convenient for the parties.
Should we gain access to the property before then, we will continue and have to order another dumpster, but we will continue with the items in the driveway at the top of the hill.
Okay. All right. Like I said, it's too new to know what access you have. I understood that you don't have access. So what the township wants to happen can happen. I'm not sure about the insurance issues. It's just going to take some time to have all of that flush out. Plus there's the issue of, is it Mousy, the potential purchaser. So all of that's got to kind of flush out. And I don't think any of it can be rushed. Okay.
Thank you.
Thank you, folks. Court does call the cases of Caro versus Cox, and then the Township of York versus Cox.
Morning, Your Honor. We'll look for York Township and the York Township cases.
Good morning, Dan Troika, appearing for Lawrence Caro.
Lawrence Carroll, plaintiff.
And where are the Coxes?
This is Laura Cox. I'm here, Patrick.
Okay, there you are.
Sorry.
All right. No, it's okay. And Mr. Cox, you'll have to unmute and turn your camera on, please.
I'm here, Your Honor.
State your name for the record.
Patrick Cox.
All right. Okay, folks, where are we on this case? That has
So,
become significantly more complicated.
Yeah.
But go
well,
ahead.
My hope is that, we're hopefully within weeks away from everything being finalized. We did get back onto the property in the last 10 days, and so that's been nice to get moving on that. We do have, I have it with me, I can't give it to you, but the new purchase letter of intent from Mr. Mounsey, that the property will be purchased the minute that the insurance claims are done. That's all been delayed. We were just able Friday, my insurance company was having difficulties getting policy information from Allstate under Mr. Carroll's insurance. They got that Friday. So now they can do up the numbers and schedule the clean out of the property, but they couldn't do that because it's all based on a percentage. So they couldn't do any of that until they had all the needed paperwork. So that was given to us on Friday.
Good morning, Your Honor. Dan Troika for Lawrence Caro. I don't really have the inside information about the status of adjustment of the claim, so I'll have to rely on Ms. Cox. I do know, of course, Mr. Caro's dealings with Allstate, but my understanding is State Farm has the lead here. I did communicate with Mr. Lilick, and of course he can speak for himself, but I understand that there has been no arrangement yet made with regard to cleanup. And as Your Honor may be aware, I am informed that York Charter Township is part of the pool that gets a certain percentage of casualty proceeds when there's a fire to cover the cleanup. From what Ms. Cox just said, I assume that they are going to fulfill their obligations, but I don't know. Just speaking from Mr. Caro, he, of course, does have some frustration in the situation as he has been economically, impacted by the ongoing litigation and the fairly radical increase in his own mortgage payments due to the township assessments. I understand that the regular assessments, including the $550 that we've talked about in prior hearings, have been made and are current through February. There's still the issue of the $13,850, which was assessed last year and has not been paid. I say it was assessed. It was incurred. I'm not sure it was. I don't know if it was placed in the tax rolls, but it was assessed in the sense that the property is deemed subject to a lien to pay for it. And there's still the balance of the original assessment, which was about 12 grand, which the Coxes have been paying off in $550 installments, of which 50 is interest, although it is our contention that that was accelerated when there was a new problem in the summer of last year. I have to preserve my client's rights. Our position is the property should be forfeited. And at any rate, the Coxes should pay in full what's owed on the assessment, so that if they did that, then we wouldn't have to have a continued proceeding. All that being said, I understand there's an adjustment process in place, and I don't know where or when that's going to resolve.
So may I speak, Judge?
Go ahead, Ms. Cox.
As soon as the numbers are in place, which again, my adjuster couldn't do anything with without Mr. Carroll's information, our hope is that all this will be taken care of. Not only will the tax assessment be paid off, so will the land contract be totally fulfilled. And then we will be able to sell the property. The letter that Zach sent me yesterday said, regardless of what happens, it just says that he has said that I want to find it. His intention is to demolish whatever remaining building structure or debris left to the land is there and restore the land to its natural state. I'm committed to initiating the demolition as soon as permissible by the township or any relevant authorities with the insurance. So we have the debris removal covered for the fire on both ends. They have just let us go in to try to look to see if there's anything we can recover from the fire. There has not been. We have had our own. We paid for a dumpster to be out there 10 days ago so that we could start getting anything else that is not part of that debris taken care of over and above what State Farm is doing. And my understanding is that York Township is in the pool. And so our insurance did authorize that $15,000 pool payment that is refundable once the property is clean, which it will be before the sale is out. Unfortunately, what started in December as us being able to sell this property to Mr. Mounsey took a tragic turn for us. And we've been now held to the timelines and to the needs of an insurance claim and everything else. We have no intention of not fulfilling our financial debt. We have done everything we have agreed to do financially from the beginning of this. The first tax assessment should be $6,000 of the 12 should be paid as of February. And actually the $550 is due at the end of this week for February. So we have maintained every financial. We just need the time for the insurance company to finish those calculations so they can schedule payout. And Mr. Carroll will be fully paid. Mr. Mounsey will be able to purchase the property. State Farm is going to come in and clean up the debris. Mr. Mounsey has agreed to clean up any debris which State Farm doesn't feel they need to.
Mr. Lilly.
Yes, Your Honor. Well, from the township's position, not much has changed. We do recognize the pool, the insurance pool. I have communicated with the insurance agents myself. They have indicated to acknowledge it, but they have not provided any, anything to the township to basically confirm that. I may be sending a letter out to them this afternoon. We have a lien on the property for the past cleanup at this point, Your Honor. Nothing has changed with respect to the cleanup of the property. we want the problem to go away just like everybody else does, you know, with the complication of the fire and everything at this point. You know, we could potentially go onto the property and clean it up, but I don't think, you know, we're in a position to do that right this very minute, just because the insurance company, and as she says, I mean, if the purchaser's going to do it, we will give them full authority to go ahead and do this. I mean, whoever can and will do it, let them do it, frankly, at this point, Your Honor. But
Well, as I
the top,
understand, all states going to come on, do some cleanup.
No, State Farm,
And
Your Honor, I'm sorry.
State Farm, I'm sorry, State
Also,
Farm is going to come on and
here.
do some cleanup. And then the purchaser is going to do the remaining cleanup. So, I mean, that's my understanding, at least is what's been said.
right, right. And the question is, when is all that going to get done, frankly, Your Honor? So we don't know.
Yeah,
The
like I
sooner,
said,
the sooner, the better, Your Honor. It's been sitting out there for an exceedingly long time, and anyway,
as I said, our insurance agent has all the estimates done. They could not proceed without the information from Allstate, which took the last several weeks to get. And Mr. Carroll did finally present that for us on Friday.
Did they give you a timeline as to how soon, now that they have all the information, everything's going to be done?
My understanding is once those numbers are done and presented, they try to close it out within 30 days. And I would think that includes the part of the cleaning. Unfortunately, and fortunately, this is the first time I've ever had to go through something like this. But that is why Zach, Mr. Mounsey, was willing to put that into our letter as well, that regardless of what happens, he is taking responsibility for anything not finished. My understanding is that my insurance policy covers 5% of the dwelling coverage towards cleanup, which should cover everything that needs to be done.
Got it. Okay. My inclination is to, because nothing's ready. I mean, we're really at the same spot. We have some more information. But is to adjourn these out to the first part of March, check in again and figure out exactly where we are. I understand your position, Mr. Troika, that your client's insisting on their remedy. However, I think even with the time frame, your client's going to be made whole, as I understand it. And it's just more a matter of everybody trying to figure it out. But if I'm wrong on that, please let me know.
I just have to preserve rights to my client. I've heard Ms. Cox say, and I've never heard to the contrary, that it is the intent of the Coxes to make Mr. Carroll whole. While we reserve our rights, we're also relying upon that. I assume that will happen. Mr. Carroll is under no obligation to sign over title unless he's made whole. So my hope and expectation is that will happen if no immediate relief is granted. I would ask Ms. Cox to send me the letter from Mr. Mounsey just so we know what's going on.
Absolutely, I will send that right now.
Thank you.
And why don't you also send a copy to York Township?
Thank you,
Mr. Lillick, so that everybody has the same documentation.
Certainly.
All right. So what I'm going to do is I'm going to adjourn this out. They say they try to close it out in 30 days. They got it last Friday. So let's shoot for March 5th at 9 a.m. Let's see if they have it done.
I don't know if anyone else would object, but I would prefer the 12th or 19th if that's consistent with Your Honor's calendar. I would also request, and also, if Your Honor will agree, I prefer to appear by Zoom for everybody. I think that's more economical at this point.
No, I'm going to make you all come down here. No, I'm kidding. You guys can. All right. March 19th at 9.
That works for me. Thank you, Your Honor.
Does that work for
Works for me,
everybody? I wasn't trying to make Mr. Troika happy at all, but does that work for everyone? All
Works
right,
for me, Your Honor. Thank you.
all right. March 19th, 9 a.m. Thank you, folks.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Are they? Oh, they are. Caro versus Cox, all of the cases, including the York Township versus Cox.
Good morning, Your Honor. Dan Troika appearing on behalf of the plaintiff, Lawrence Caro. I do believe
Coxes here.
the Coxes are here as well.
Lawrence Carroll plaintiff.
Your
There
Good
they are.
morning, Laura.
Okay. And I think Mr. Lilick is not here.
Your Honor, I had a chance to
Lilick
speak
is
with
not
them.
here.
Something did come up.
Okay.
I did speak with them to get an update from the township perspective. So we are where we were last time. The reason, which others can speak to maybe, is that the insurance companies are still talking. For Mr. Carroll, it remains my position, to Your Honor, which I'm stating for the record, that the defendants did not comply with the terms of the court's forfeiture judgment, and therefore the property should revert to Mr. Carroll as a matter of law. If the court is not going to do that, we are sort of stuck on insurance time. And I don't know that there's anything. I mean, I have no doubt that Coxes are pursuing that diligently, and so is Mr. Carroll. But none of us have the ability to force anything unless we invoke things like the statutory appraisal process or file suit, which in my judgment is just premature for that. I am of the opinion that this claim will be paid in full, and it's just a matter of the sort of normal sort of, twiddling of thumbs that insurance companies do. So, from that point of view, if Your Honor would agree with my first point, then we believe the property should be forfeited to Mr. Carroll. If not, I don't know that, from my point of view, I don't know that we're in any hurry to come back, because there's really nothing anybody can do in the current posture of the case until we actually get a definitive response from Allstate and State Farm, which we are told is coming, by the way. Mr. Carroll calls them and, and basically the check's in the mail. So they're not denying the claim. It's just, they're adjusting it.
All right.
Your Honor, could I speak? This is Mrs. Cox.
Yes, ma'am. Go ahead.
Good morning. So I just wanted to speak real quick updates on both situations. As far as the township is concerned, the cleanup is progressing as it can after the fire, but the insurance company has given the township a $15,000 deposit that they keep until the property is clean. So in my opinion, obviously it's up to you, that situation is resolved and we are pursuing the clean. As far as the forfeiture, it was based on the tax assessment, which Patrick went to the township on Friday of $13,000 ready to give somebody. They didn't know what our balance was on that tax assessment. My understanding is that it was never assessed to Mr. Carroll. So if I can pay that to somebody today, or we can pay that, I'm sorry, that should alleviate the forfeiture. Whether I pay it at the township or if it's already been assessed, I pay it to Mr. Carroll. But we've taken care of those steps on both as far as we can until the insurance company closes this situation.
So, Your Honor, it certainly would be helpful if they could do what Ms. Cox just indicated. I will just register my disappointment that she tried to give money to somebody and they didn't take it. But I do think that would be appropriate. I want to note, as I mentioned before, and while it certainly wasn't intentional, the effect of what's happened to this case, that Mr. Carroll has gotten his own mortgage escrow jacked up, which has actually created a huge hardship for him. So while paying the assessment isn't going to solve the current year's escrow issue, it would mitigate the future. So yes, we would ask that they go back and take care of that issue. That is one of the running issues that's created problems for us.
All right. Ms. Cox, you want to give another shot at trying to pay somebody and seeing if they'll take the money?
Yes. You know, when Mr. Carroll had given us the numbers earlier in a previous court, it was 13,500. And finally, Mr. Toth called my husband late yesterday and said it was 14,000 something, but they couldn't find it because they kept saying, oh, it's paid because of the deposit that the insurance company gave them. So trying to sort all of that, I just want to make sure that we've taken care. We did ask for an advance from our belongings portion of the insurance to cover this so that it could be taken out of your courtroom. We just want to finish getting the insurance claim settled so that all of us can move forward. But everything should be in place that there, in my opinion, there's no reason for a review because everybody has what they need at this moment. I've continued to pay every mortgage payment and the additional $550 a month without fail.
So if Your Honor isn't going to grant the relief of a simple forfeiture of the property, which Your Honor has not done in the past, and I understand, and I'm just creating a record. I don't doubt that what Ms. Cox said is true. I work with enough townships, and Your Honor, you've seen enough of them that sounds par for the course.
Yes, it does.
Part of my thinking here is I'm not anticipating or advising my client to really do anything other than sort of keep some pressure on and then to, be made whole. And I believe from Your Honor's prior comments that, Your Honor is on board with that program. There will be money. And when there is money, then we'll be, at a minimum, taken care of and paid off. I'm at a point where I think, and I suspect Ms. Cox will agree that we can put it off maybe like 3 months because Your Honor, nobody on this call can control the insurance companies unless and until we have yet another proceeding, which to me is a last resort. I am trying to be protective of Mr. Carroll's, costs because he has suffered through this whole thing. And so that's where I'm at. I'd bounce it like 3 months. Hopefully we get paid in the meantime, in which case we will file a dismissal and I'll be happy.
Okay. And that, Mr. Troika, great minds think alike. I was actually looking at my calendar and I was thinking 3 months out, somewhere around that period in time, because I don't need everybody coming back. We thought we might have everything resolved. End of July. Give me something.
End of July. July 23rd at 9 a.m.
All right. So what I first of all will do is I'll adjourn this out to July 23rd, 2024, 9 a.m. Here's what I would indicate regarding the payment to the township. Since quite frankly, it benefits all parties. I will sign whatever orders necessary so that the township can get that straight. So that, Ms. Cox, you can pay it to them and get it done. I wish Mr. Lilick were here so that I would direct him to prepare the order. Mr. Troika, if you could communicate that to Mr. Lilick so that the Coxes can get that paid, and then they can straighten out their accounting however they want to straighten out. But I want the Coxes, they're operating in good faith with everything, and so they should be able to pay those funds over.
Yeah, I'm all for them paying money. I did have a conversation with the township. I'm sure, I'm confident that if the Coxes have money that they want to give to the township to take care of this assessment, I can get the township to accept it. So I'll work with Ms. Cox to make sure that happens. I guess what I would suggest is let me try that first. If it doesn't work, we can submit an order. But this is really there's not a substantive issue here. It's just the Coxes obviously need to know what the amount is and to be comfortable that it takes care of the assessment. So I'm sympathetic to the issue of needing to liquidate the amount, and I will work to make that happen.
Ms. Cox, is that satisfactory to you?
Yes, my husband and I appreciate it.
Okay, so let's see if we can get that worked out. If not, I will sign whatever order is necessary to do that. Okay,
Thank-
folks?
Thank you, Your
Thank
Honor.
you.
We'll see you July 23rd, 2024.
Thank you.
Thank you.
In the interim, I'll miss all you guys. No, I'm just kidding. Right.
Yeah, we could come back for a social visit.
Okay. Thanks, folks.
Thank you.
Thank you, Your Honor.
Thank you.